May I please? In item number 5, Lordship, I have to file additional affidavit, Lordship. Lordship, I could not contact with my client, Lordship, so 2 weeks, which time will be granted. Lordship.
Sorry,
In item number.
you
5,
filed
Lordship,
additional
which-
affidavit.
But I could not contact with my client, Lordship, so sometimes.
Given some time.
Yeah.
Adjourn on the prayer, Mr. A.T. Sarkar and on petitioner. In order to enable the petitioner to file the additional affidavit as sought for.
Hello.
Item 1 for motion.
May I please, Lordship? In this case, my lord, the entire family of the petitioners, my lord, implicated in this case, my lord. Whereas, my lord, as per inquiry report and reference only against the petitioner number 2, my lord. At that 2, my lord, petitioners proved their case, my lord.
If others are included, you file separate application on behalf of others, will pass a separate order that they cannot be declared. Whosoever was referred, you file a separate petition on his behalf, will consider his case on merit. Now, by filing a joint petition, you are asking for 2 judgments within one
No,
judgment.
my lord, only one judgment. Only one judgment.
Mr.
declared.
Motin, according to us, it is 2 judgments. Because one cause of action is somebody is wrongly declared to be foreigner, although proving his citizenship. Other cause of action is somebody declared foreigner without being referred. You segregate the 2.
No, my lord.
We'll hear you.
My lord, in this case, my lord, my lord, petitioner number 1, 2, 3, 4, and 5 family members, one application, my lord.
Sorry,
One application number.
what one application?
One application number registered against the petitioners. my lord.
Against whom it is registered?
Petitioner number 2, my lord, but as per notice, my lord, issue notice all the against all the.
Mr. Motin,
Yes.
we hear petitioner number 2 separately on merit.
Yes.
Rest we delete, you file a separate petition.
That may be.
Or we dismiss the petition for
That may be.
misjoinder of causes of action.
No.
Which one you want?
Then, my lord, petitioner number 2 in this case,
2.
my lord.
2 will hear on merit.
Yes, my lord.
Rest of the petitioner, as they had been included without being service of proper notice, without being referred, will pass separate order in respect of
Yes.
those petitions.
In this case, my lord.
Otherwise, it will be 2
petition.
judgments within one judgment. So how can you write 2 judgments within one judgment? First judgment for number 2 on merit on citizenship. Second judgment for the others. They were declared foreigner without serving notice. It is stated that although the reference and notice was against the petitioner number 2, Rahima Begum, but the other family members of Rahima Begum, namely the petitioner number 1, Abdul Qadir, petition number 3, Ramizat Islam, petitioner number 4, Kazima Sultana, petitioner number 5, Karima Sultana, and petitioner number 6, Aklima Sultana were also included in the said proceeding and were declared to be foreigners by the common opinion dated.
Page 82.
Common opinion dated 17/9/2016 in FT case number 35, so 2015 of the Foreigners Tribunal number 3,
No, my lord,
Morigaon.
Page 82, my
Please
lord.
don't go on disturbing Mr. Motin. Let us come do our work. We are going by the information provided in the cause title. If it is wrong, you correct it. You correct your petition. Don't try to correct our order. As 2 separate causes of action had been espoused in this petition. 1, that without due consideration of the merit, the petitioner number 2 had been declared to be a foreigner. And the second, that the petitions number 1, 3, 4, and 3, 4, 5, and 6 had been declared foreigner without appropriate service of proper notice and reference. We intend to segregate the two causes of action. Accordingly, the petitioners number 1, 3, 4, 5, and 6. Please take your seat. Don't disturb when I'm dictating the order. And if you want to say something, cancel the order. Mr. Motin, you argue, please. You argue. And we don't, when we're dictating the order, we dislike this habit of constantly disturbing us. If any wrong fact had been incorporated, you please point out at the end of the order. Definitely it will be corrected. But that doesn't mean that every word you are going to interrupting. Adjourn to be listed again. Next item.
Sorry, ma'am.
You invited it.
Item 2.
And 3 or 4 times I have been requesting you, please don't disturb when the order is being dictated.
Maybe your worship. My lord, page 23, my lord. Page 23, my lord.
Page 23. Behula Khatun. Who is the father of Behula Khatun?
Page 23. Haran Ali Sheikh is the father, my lord. 1966 Budangli.
Who is the father?
Haran Ali Sheikh, my lord.
Haran Ali Sheikh. Now, which document will
My
show?
lord, page
Haran Ali?
25 also, my lord. Haran Ali Sheikh and Sakina Bibi, mother, my lord.
Page number.
25, my lord. Borolation 1970.
Haran Ali Sheikh is the father and Behula Khatun is the petitioner.
Yes, daughter.
Which document will show?
Father execute, my lord.
Page number
Page number 69, my lord.
69.
Nine. And petitioner also, my lord, produced, my lord. GP certificate, my lord.
Oh, that's so is my God.
Gao Panchayat certificate also produced, my lord. That is, my lord, page 43. And secretary was examined.
Haran Ali, Haran Ali, Haran Ali Sheikh. Where is the school certificate?
School certificate is page 42, my lord, but headmaster was not examined, my lord. And GP certificate was produced and secretary was examined, my lord.
Certificate. Register Bhangori. a recent experience is showing school
30th
certificates are turning out to be the original school registers are all fabricated.
But in this case, headmaster was not examined. Your lordship.
No, headmaster will bring the school register, depose from that, but the school register itself are fabricated.
My right, yesterday.
It's already 3 or 4 cases have been detected. We do one thing, it's your convenience now, inconvenience now. We'll call for the school register before this court. Verify for herself whether it is a dependable document. If it is yes, we'll accept it.
Yes, lordship.
What else to do?
Yes, lordship. But in this case.
See, when the conduct of few unscrupulous persons makes the system to lose faith, this
My lord, yes,
this is the natural consequence.
Yes.
No one can help it.
Well, yes.
The petitioner claims Haran Ali Sheikh, son of Posu of the 1966 voters list of village Meadowville to be her father. Although Haran Ali Sheikh, son of Posu, had deposed as DW2, stating that the petitioner Behula Khatun is his daughter, but reliance is also placed on a school certificate issued by the headmaster of which school? Of Mondia ME Madrasa. Full stop. But the headmaster had not been examined, nor the original school records been produced before the tribunal. The education department through whom? Where is Madam Dekha gone? This is of which district, Mr. Ahmed? Dhubri. The district elementary through the district elementary education officer Dhubri is directed to produce the original school records, school admission register of Mondia ME Madrasa before this court for its examination on the next returnable date. As regards the information that may be contained therein regarding as to who is the father of the petitioner, Behula Khatun. A copy of this order be provided to MS B. Dekhan, B. Dekhan and Council for the Education Department.
Obligation.
List also.
Item 3.
We will call. If it is true, we accept it.
Made the lordship. Lordship, in this case, petitioner's father's name appeared in 1966, the list.
Page number?
Page 22, lordship.
20,
22.
22. Who is he?
Abdul Aziz.
Abdul Aziz is the
of the
father.
petitioner, lordship.
Now, which document will show that
Page
Azmal
38,
Haq is his son?
page 38, lordship.
38.
In 39. In 39, first name is Abdul Aziz, is Adab. And serial number 1108 is.
Achha, this is a subsequent voters list of 2011. So Abdul Aziz is still alive.
Alive lordship.
And who is the petitioner?
Petitioner is Ajmal Haq.
Azmal Haq. Heard Mr. J. M. Suleiman and counsel for the petition. The petitioner Ajmal Haq had been referred to the Foreigners Tribunal number 4, Kamrup Metro, for rendering an opinion as to whether he is a person who entered the state of Assam on or after so and so, 1971, resulting in registration of FTK of case number FT Dutaman bracket page 70. The tribunal rendered an opinion dated 30/11/2019 declaring the petitioner to be a foreigner. Being aggrieved, the state petition is instituted. In the writ proceeding, the petitioner relies upon the voters list of 1966 of village Kathuri police station, Lokhipur in the Golpara district, which contains the name of Abdul Aziz, son of Rahman Ali at serial 102. The petitioner also relies upon the voters list of 2011 of also of village Kathuri, which contains the name of Abdul Aziz, son of Raham Ali Mullah at serial 1102, and that of Ajmal Haq, son of Abdul Aziz at serial 1108, and both are shown to be residing in the same house number 482. Accordingly, the petitioner claims that the burden under Section 9 of the Foreigners Act 1946 had been discharged to prove that he is a citizen, inasmuch as the voters list of 2011 shows that he is the son of Abdul Aziz, and the name of Abdul Aziz appears in the voters list of 1966 of the same village, and meaning thereby that he is a citizen. In view of the above, remanded back to the tribunal to examine the voters list of authenticity and acceptability of the voters list of 1966 and 2011 of village Kathuri. And thereafter pass a reasoned order the petitioners to produce the complete voters list of the intervening years between 1966 and 2011 as regards village Kathuri for the examination of tribunal. The respondents in the Home Department make their own verification and submit a report to the tribunal upon doing the needful reasoned order.
Obliged.
Item 4.
Yes, item 4.
My lord, order, my lord, page 57 kindly be seen the order of the Learned Tribunal lordship. The evidence of my lord,
We don't want to see the order to
my
begin
lord,
with.
evidence of DW2 was closed lordship. He was
Sorry.
not cross-examined. Yes, lordship, lord.
First, you discharge your burden.
Yes, lordship, yes.
Who is the father? And
My
Abdul
lord,
Razak, who is the father?
Abdus Samir.
Abdul,
Abdus Samir, sometimes it is written as, kindly see my lord, page 22,
page 22.
22 lordship. My lord, Abdul Hussain, my lord, is a grandfather, lord.
Abdul Hussain is the grandfather.
My lord, Abdul Hamid is paternal uncle.
Abdul, forget about paternal. Who is the father?
My lord, A. Samad, my lord.
A.
Abdul
Samad is the father.
Yes, lord.
Okay, 65.
My lord,
Harun Salah. No. And which document will show that Abdul Razak is son of
my
A.
lord,
Samad?
1993 lordship,
Page number?
my lord, it is page number 32 lordship.
32.
Page number 30.
Different.
Village is
This
different.
is different village lordship.
How will you prove?
My lord, in reference, my lord, kindly be seen, kindly see the, my lord, the total list of 1977 lordship, after shifting lordship.
Page number?
My lord, 77 is at page number lordship, my lord, 28.
28. 29 is the vernacular.
Yes, lordship.
Uh,
My lord,
Samed.
My lord, Abdul Samad, it is Sorai area lordship, after shifting lordship.
Yes. After seeing this, what will the?
My lord, A. Samad is my
Understand.
father.
But A. Samad is the son of Hussein Ali.
My lord, Hussein Ali.
Earlier
Yes.
Samad was son of Abdul
Abdul
Hussein.
Samad lordship. Now, my
So how
father,
do you know that Abdul Hussein and
my-
Abdul Ali are same?
other family member lordship. My lord,
Hmm.
Abdul Hamid, my paternal uncle. My lord, he is son of Hussein. My lord, he was in 1965, he was my lord also their lordship. My lord, page 22. My lord,
What about Hassan?
my lord, Hassan is also my lord.
Where did Hassan go?
My lord, my lord, in the same village lordship, he separately lost.
He did not migrate.
No,
He remained in the original village.
my lord. Now,
You produced the 1977 voters list of village Harusala, which may contain the name of Hassan, because Hassan did not migrate. His
my
name
lord,
will be
it is
there.
not there, lordship. It is not there. But the two brothers,
If everybody else migrated, Hassan did not migrate. His name will continue in 77 in Harusala. You let us see.
my lord, I have no such instruction, lordship. Now, one thing, lordship,
Mr. Ahmed, we are not dependent on what instruction you have, what instruction you don't have.
lordship, that is.
We have to do our work to adjudicate your matters. We want that document. Produce it. If you produce and Hassan continues to remain at Harusala, that means others had migrated, Hassan did not migrate.
Then I have to file my lord additional affidavit
File.
after hearing. My lord, apart from that, lordship, my lord, the BW1, my lord, possibly, my lord, in his deposition stated that, my lord, your family shifted, my lord.
That is your self-declaration.
My lord, the paternal uncle Abdul Hamid was, my lord, produced and submitted examination.
Mr. Ahmed, there is nothing called paternal uncle. You'll have to also prove that that man is the paternal uncle. You just call one person to be paternal uncle, he does not become a paternal uncle.
My lord, I will file additional.
You find it. Find some more convincing and check up the voters list, whether this family had actually migrated or not. The election commission may produce the relevant voters list of village Horusala and Sarai Zoria, in as much as there is a claim that Abdul Samad of the 1965 voters list of Harusala, Abdul Samad, son of A. Hussein, of the list of Harusala, is A. Samad, son of Hussein Ali, of the 1977 voters list of Sarai Zoria, by making a claim that the family had shifted from Harusala to Sarai Zoria. It is stated that the other family members, except for A. Hassan of the 1965 voters list, had shifted, but Hassan continued to remain at village Harusala. Election Commission may verify whether the name of A. Hassan continues to exist in the voters list of 1977 and later in respect of village Harusala. List on so and so for the required information.
Item 6 for admission.
My please, your lordship. My lord,
Amir Ali Khan, who is the
Yes.
father?
page 22,
Page 22.
Matab. Matab is the father of the petition.
Mata is the father.
Yes, Matab.
Page 22. Matab.
Yes,
Matab is the father. And which document will show Matab is the father?
page 24,
Page
page 97, lordship.
97.
Page 97.
97?
Yes, sir. Where Matab Ali Khan.
No, the last
97
page in my record is page 69.
Yes, lordship.
There is no page 97.
Sorry, lordship, voter list of 97, page 25.
25. Village is different.
Lordship, village, that is Matragula and here Balasar. Balasar and Matlagura under same panchayat. Lordship, may in the same page, may kindly see, the voting center is same. 96.
Mr. Council,
Lordship.
America and India are also in the same planet. Do you mean to say it is the same?
Lordship, voting center is same. Lordship.
Voting center may be same, but voters list are identified from the village point of view, not from the voting center point of view.
In every play.
You prove that they are one and the same. The petitioner claims that Motab, son of Pathan of the voters list of 1966 of village Motar Ghola at page 22 is the father of the petitioner. To prove that Motab is the father, reliance is made on the voters list of (1997) of village Balarshore, which contains the name of Motab Ali Khan, son of Pasan Ali Khan at serial 712, and that of Amir Ali Khan, son of Motab Ali Khan at serial 715. But it is noticed that the voters list containing the name of Motab is in respect of village Motara Ghola, and the voters list of 1997 containing the name of Motab Ali Khan is in respect of village Balarchor. Petitioner may produce any relevant material which may indicate that the family had shifted from village Motar Ghola to village Balarchor. This after a week.
Item 7.
May I please, your worships?
See, in most of the cases, Mr. Hussain, we are following a procedure of looking at the follow-up voters list and the earlier voters list of the two villages. Why don't you invoke that procedure?
Lordship, I was
Instead
under-
of just arguing
Yes, Lordship.
and saying all kind of things, why don't you invoke? You can tell Mr. Ali beforehand that I have a similar case. Please try to bring the document. He'll cooperate. He'll save a lot of time. And in many number of cases have been allowed by following that one. In fact, the election commission themselves say, yes, it appears that there is a shifting. So why don't you take help of that procedure? If that procedure fails, we'll think of something different, but whosoever has any case of shifting,
Yes, Lordship.
I think you can start, start making a request to Mr. Ali that we want the voters list of these two villages of this period, complete list. And you take note, ask them and keep it in the file. When the matter is taken up, we can use it. It will save a lot of effort from your side. It will save a lot of time from our side.
Obliged, Lordship.
Item 7.
May I please, your
Is
worship?
there any shifting?
No, Lordship, Mary Domain,
If there is shifting beforehand, you give the requisition and then.
Mary Domain,
Sorry,
ma-
Musammad Jarina Khatun, who is
Jarina
the
Khatun.
father?
father's name is page 16, Lordship.
Page
Father-
16.
Page 16. Sahed Ali.
And Mr. Ali, you also maintain a diary? Whosoever makes a request, take note of the two villages, take note of the case number and the likely date it is going to be listed. Who is the father? Sahid Ali?
Sahed Ali, Madar Meher Banu.
Very well.
Then
Now,
1970.
which document will show Sahid Ali is the father?
Lordship, Gaugura certificate and my brother's evidence. Gaugura certificate is page 28.
Mr. Borhue, before you go to Gambur and brother,
Yes, brothers, others I have no document regarding with the name of my
how does
father.
the Gambura know about this fact?
Because he is the resident of that village, that's why he is told that. And my brothers.
Every resident may not be knowing
not-
everything.
Correct, I agree with your worship.
So if we are correct,
Yeah.
you agree, then please.
Brothers evidence is very much important.
How do you know that that man is the brother?
Lordships.
Anybody can come in and claim that I am the brother and this is my evidence.
And
How do you know that he is the brother?
Lordships, in the NRC final draft of
NRC is not
my
acceptable.
brother sister's names included, not accepted, but
NRC is not admissible in
But it's-
evidence.
the documents has to be additionally to be taken as a consideration. Lordship. My brother's evidence may be,
Brother evidence, we'll look into it, but first show that that man is the brother. Is DW?
my evidence is DW2, page 38.
It is stated that BW2 is the brother of the petitioner. Petitioner may produce any material which it may show that DW2 is actually the brother of the petitioner. After a week, next item.
After 2 weeks. Lordship.
Once you show that that man is the brother, the rest of the thing is very clear and easy for you.
Lordship.
Item 8 for hearing.
Yes, join up, yes, sir, will be further.
My lord, the proceeding herself is the voter in 1966.
Page number?
Page 20. Page 20, vernacular at page 21.
He's
Joined up Khatun, wife of Akbar
joined up Nessa, joined up Khatun Bibi, wife of Akbar.
70 also.
How did the tribunal deal with this matter? This evidence?
My lord.
Why was it rejected?
My lord, the order. Paragraph 7,
Para,
7.
page number
My lord, page 45.
45.
And para 6 also disclose that there are some age discrepancy. So not believe.
So let it remain. How this voters list, why was it rejected?
My lord,
Hmm.
Lordship may kindly have a look at paragraph
number.
6 at page 45, same paragraph, same page. Her name is in the NRC also, and between the NRC and the voter list of
Public.
1966, there is some age discrepancy. And that has been picked up.
That are the only thing. Citizenship ding का पूरा है वो पहला मुख्य पर है. Even if you prove you are the so in a lot hopefully it will not establish as citizenship. How will you prove that Zainab Khatun Bibi of 66 is the petitioner?
My lord,
You have to prove that.
he received she received the notice, my lord.
No, she noticed, but how do you prove that this person is that person?
My lord, because of the
You prove that you can, you have made out your case.
yes, lordship. my-
You don't have to go to any other material. You just prove that Zainab Khatun Bibi of the 66 voter list is the petitioner.
my lord. Her husband is there, my lord. Husband is Akbar Ali is the husband.
Then Akbar Ali will also have to prove that he is that Akbar Ali of 1966. How do you prove it? Do you have anything? Will not go by the same reasoning as the tribunal.
My lord.
You produce any material to show that Zainab Khatun Bibi of 66 is the petitioner.
My lord.
You think about,
Yes.
must be something must be there.
Yes.
If really this is the person,
Yes,
definitely something or the other will be there.
well,
The petitioner may produce any relevant material to show that Jainab Khatun Bibi of the 1966 voters list of village Dingdinga at page 20 of the writ petition is the writ petitioner Prosidi herself. List again.
Item 9.
May I please look?
9 years.
My lord, page
Amila Khatun, where is
Page
the
21,
page 21?
21, my lord, the grandparents' name is there, my lord, in 66 voter list. 22 is the, my lord, vernacular. Sumor Devani, Manikjan Nessa is the grandparents. And my lord,
Sumo Devani is the father.
grandfather, and
Grandfather.
Manikjan Nessa is the grandmother.
Now, who is the father?
This is the 66 voter list. My lord, father is at page 24. Page 24 vernacular, Sumor Devani, grandfather, Manikjan Nessa, grandmother, Abdul Gofur, my lord, father,
Is the father.
father. In the
This
same
is of 1970
17,
of village
Tapeshwar.
Tapeswara.
66 also.
Now,
Tapeshwar.
which document will show that Hamela is the daughter of
My lord,
Abdul Ghaffur?
Lord, there is no documents, my lord, because he was my.
Then how will you prove?
My lord, father deposed before the tribunal.
Where is the evidence?
Evidence is, my lord, at page 63,
Page 60.
father's evidence. DW2 Abdul Gofur.
He was to be except for it. State nothing except the truth. So, yes, Mr. Sharma. Yes, Lordship. S.U. Ahmed.
Yes,
Heard Mr. S.U. Ahmed, then counsel for the petition. Petitioner Hamela Khatun had been referred to the Foreigners Tribunal number, Foreigners Tribunal Jorhat for any opinion as to whether she resulting in case number FT/SBR/151/14. Opinion dated 21/8, declaring to be petitioner. In the writ proceeding, the petitioner relies upon the voters list of 1966 of village Tapeswara, which contains the name of Chomar Diwani, son of Bhomar, at serial 12, and that of Manikjan Nessa, wife of Chomar, at serial 13. It is claimed that Chomar Diwani is the grandfather and Manikjan Nessa is the grandmother of the petitioner. Reference is also made to the voters list of 1970 of village Tapeswara, which contains the name of Somar Devani, son of Bhomar at serial 17, Manikjan is a wife of Somar at serial 18, and that of Abdul Ghafoor, son of Somar at serial 19, and all are known to be residing in the same house number 5. Abdul Ghafoor had deposed before the tribunal as OPW2. Abdul Ghafoor, son of Samar Diwani of village Tapaswara, had deposed as did the OPW2, wherein he makes a specific statement that he has 5 sons and 3 daughters, and the names of his daughters are Hamela Khatun, Hawa Khatun, and Hafiza Khatun. He specifically states that the writ petitioner proceedee is his daughter Hamela Khatun. Full stop. In the cross-examination by the state, the evidence rendered that Hamela Khatun petitioner is the daughter of the OPW2 could not be demolished in any manner. In the circumstance under the law, the evidence of there is no reason as to why the evidence of OPW2 should not be accepted. And accordingly, accept that. And accordingly, conclude that the petitioner had discharged the burden under Section 9 of the Foreigners Act 1946 to discharge the burden that she is a citizen. In the circumstance, matter remanded back to the tribunal to allow the state respondents to cross-examine OPW2 to further cross-examine OPW if necessary. The state respondents in the Home Department may also make their own inquiry and verification in the family of Abdul Ghafoor, son of Samar Devani of village Tapeswara, to arrive at their conclusion as to whether Hamela Khatun is a daughter of Abdul Ghafoor. Upon doing the needful, a report be submitted before the tribunal. Upon doing the needful, a reason order be passed.
Only one, my lord, the father of petitioner, whether he is alive or not, my lord, I have no, my lord. information.
Hey, you state before the tribunal. If he is not alive, how can you cross?
Yes.
Will you be able to cross? Then he gets a benefit.
Yes.
No?
Oblige me.
গল্প আৰম্ভ কৰি দিয়ে। Sounds good. Yeah, we thought so. In paragraph 17 of the opinion of the tribunal, it had been held as extracted. The reasoning of the tribunal appears to be absurd, inasmuch as the tribunal had accepted that from the depositions of the witness, it is proved that the proceedee is the daughter of Abdul Ghaffur. But the proceedee had failed to prove that her father to be the son of Samar Diwani. The voters list of (1970) of village Topeswara shows the name of Samar Diwani, son of Bhomar, and Abdul Ghaffur, son of Somar, at serial number 97 and 99, and both are shown to be residing in the same house number 9. If the two are, if Abdul Ghaffur is not the son of Samar Diwani, no reason is forthcoming from the tribunal as to why they are residing in the same household. The further reasoning that the proceedee failed to prove the existence of our ancestors prior to 1996, and therefore to conclude that the proceedee had failed to discharge the burden, is also unacceptable in law, inasmuch as if the father and the grandfather existed in the year 1966, that is enough of a material to conclude that the petitioner, that they would be citizen under the law, and therefore the proceedee who had discharged the burden to prove that he is the daughter of, she or he, that she is the daughter of Abdul Ghaffur, had also discharged the burden.
Obliged.
Item 10.
May I please?
Dos.
Yes, Sahil Ali, who is the father?
Madam, kindly see page 23, madam. Petitioner is the voter along with his father. Annexure 4, madam.
Who is the father?
My father name is Mughal Ali. I am Syed Ali. The petitioner is Syed Ali.
93, Mughal Ali is the father.
Mughal Ali is the father.
Village,
Village, my lord.
Bortola.
Number 2, Kaplaburi.
uh,
Two village name in under one.
no,
village,
which
my lord.
is your village?
My village name is number 2, Kaplaburi.
Kaplawari is the village of the petitioner.
My lord, my lord.
Now, how would you know that Mughal Ali is a citizen?
My lord, I am the son, my lord.
We
When I-
know you are the son.
My lord.
How do you know that your father is a citizen?
My lord, my father name in the voter list in the year 1970, my lord.
Page
And
number?
my grand page number, my lord, 17, my lord.
17.
Along with my grandfather, Wahid Ali, my lord, and my grandmother is Nobitun Nessa. My father name is Mughal Ali. It is Nobia.
This is of village Nodia.
my lord.
The petitioner claims refers to the voters list of 1993 containing the name of Mughar Ali, son of Ahirka at serial 535 and that of Syed Ali, son of Mughar at serial 538, and claims that he is the son of Mughar Ali. On a question being asked as to what materials are there to show that Mughar Ali himself is a citizen, reference is made to the voters list of 1970 of village Nodia, which contains the name of Mughar Ali, son of Ahir, at serial 252. Although there is a similarity in the names, but the two villages are different, petitioner may produce any relevant material which may show that the family of Mughar Ali, whose name appeared in the voters list of 1970 of village Nodia, later on shifted to village Koplavori.
In between another village, my lord, there
It is
is Kolkata
stated that
village.
in between there is a shifting to
Within a
another
radi-
village.
Within a radius
All
of-
relevant materials may be produced to substantiate the shifting.
only within a
how
radius of
much
6
time-
kilometer, my lord,
how
two
much
times shifted.
How much
Due to-
time you want?
But, 1 week is enough, my lord.
Something, it's list after a week is paid for. Produce the materials, produce. Take help of Mr. Ali.
My lord, Bhutan is
List after-
itself says, my lord, my grandfather and father belongs to village Nodia for the year of 1966 and 70. And in the year 1985, my lord, my father name has been shown in the village Kolkata, my lord. And in the year 1993, my lord, after erosion by Brahmaputra
Mr.
River,
Council, all the statements are correct, provided the names appearing in the three voters list, they are the same person. You have to prove that.
Leave it. Leave it.
Item 11,
Uttam Das, DC Das. None appears for the petitioner when the matter is called. List again. Upon subsequent non-appearance, appropriate order shall follow.
12,
It's item 12. Bokul Rani Saha, who is the father?
There is Abhay Saran Shah, page 21, annexure
Page
21.
21. Abhay Charan Saha is the father.
Father. Priya Bala Shah is.
Hmm. রেজিস্ট্রি কোথাও এখান কি অ্যাকসেপ্ট করেছে হোয়াইট হয়ে গেছে এখানে কি একটা আছে নাই এটা কপি সাইজ হতে কত না সাউন্ড দিয়ে এখান থেকে ঠিকই আছে পারি বলবো পারি This is of which village? Sohar Borpeta Road.
Ward number 2, Lordship.
Which document will show Abhay Charan Saha is the father?
Lordship, one municipal certificate.
Page
Annexure
number?
4, page 26.
Municipal certificate. How does the vice chairman know? Is there any public record? No.
Yes. Subsequent voter list is not available for them.
Mr. Council, how does the chairman of the municipal board know that Bokul Rani is the daughter of Abhay Charan? What is the source of knowledge of that person? No knowledge. Then the certificate has no value.
Our younger brother deposed before Mr.
Younger brother, where is the deposition?
Page 47, Lordship.
47.
And page 46 is type of Lordship.
Hmm.
Page 46.
Deposition of DW2 Prakash Chandra Saha, son of Warpeta Road. Interesting to hear. Did the name of Prakash Saha and Abhay Saran Saha appear in any voters list
With her
together?
mother, Lordship.
Ah,
With her mother, not
mother, where is it? Mother is Priyobala.
father.
Where is the mother?
Page 29, Lordship. 2010.
29. Prakash Chandra Saha,
Is serial 450
Priyobala,
and 454 serial number
and it is also of the same village,
Border town, Lordship.
Borpata Road town.
And 1997 voter list also there.
One is good enough. Did you cross-examine Prakash Chandra Saha? No,
Cross examination.
cross-examine. This is cross.
Prosper. In file affidavit in
Acha, ye affidavit.
evidence and affidavit.
Heard your name, please?
A Hussein.
E.
Hussein.
Hussein. Heard Mr. A. Hussein and counsel for the petitioner, also heard Mr. G. Sharma and counsel. The petitioner Bokul Rani Saha had been referred to the Foreigners Tribunal number 9 Borpeta for rendering an opinion as to whether she is a person who entered the state of Assam on or after 25/3/1971, resulting in registration of FT 9th case number 409/715. The tribunal rendered an opinion dated 9/8/2017 declaring the petitioner to be a foreigner. Being aggrieved, the said petition is instituted. In the writ proceeding, the petitioner relies upon the voters list of 1965 of Sohor Borpeta Road, Ward number 2, which contains the name of Abhay Charan Saha, son of Govinda at serial 399, and Priyobala Saha, wife of Abhay, at serial 400, and both are shown to be residing in the same house number 122. Reliance is also placed on the voters list of 1997 of
Se-
1997. Where is that? 97? 29 is to 200 and 2010.
'97 is page 31, Lordship.
31.
And
On the
30
voters list of 1997 of Borpata Road, Ward number 1, which contains the name of Prakash Chandra Saha, son of Abhay, and that of Priyobala Saha, wife of Abhay, respectively at serial 347 and 351, and both are shown to be residing in the same house number 104. Reliance is also placed on the voters list of 2010 of Borpeta Road, Ward number 1, containing the name of Prakash Chandra Saha, son of Abhay Chandra Saha at serial 450, and that of Priyobala Saha, wife of Abhay Chandra Saha at serial 454, where both are shown to be residing in the same house number 104. Prakash Chandra Saha had deposed before the tribunal as DW2, wherein it stated that Abhay Charan Saha was his father and the proceedee Bokul Rani Saha is his sister, being the daughter of Abhay Chandra Saha. A reading of the cross-examination by the state authorities do not indicate that the evidence rendered by DW2 Prakash Chandra Saha could be rebutted in any manner. If the evidence of DW2 is accepted, it can be established that the petitioner Bokul Rani Saha is his sister. And as the name of DW2 Prakash Chandra Saha appears along with Priyabala Saha in the voters list of 1997 and 2010 of Borpeta Road, Ward number 1, and the name of Priyabala Saha appears along with Abhay Chandran Saha in the voters list of 1966 of village Borpeta Road, Ward number 2, prima facie it appears that the petitioner had established that she is a citizen of India. What do you know? This is clear. We declare it here only because cross-examination is over, and what will you do in the tribunal? Nothing more to do. Prima facie nobody is satisfied. That's the thing. Accordingly, the red petitioner Priyabala Saha is declared to be an Indian citizen, and further that she will be entitled to all such rights and liberties that may be entitled under the Constitution of India.
Item 13.
13
May I please,
is
Your Lordship?
Abdul Jabbar and 4
Abdul
others.
Jabbar.
Why
The
4 others?
Others are children. No. Along with wife.
Same problem.
No, here is the father's name and along with the mother's name appeared. Earlier case along separately filed wife's lawsuits.
Earlier means?
Earlier
which one?
means item number 6.
What
7.
happened? What happened to item 6?
Item 6 lordship directed me to produce the brutal list along with his brother's name.
To
brother's
something,
debut
huh.
address.
So here what do you do? Same order.
No, this case, here the Abdul Jabbar has established his citizenship with his
No,
father.
no. What we're asking for
Lordship.
this case also, do we need the same material or this can be decided without
Sir.
those material?
This is separate material.
It can be decided. We can hear.
Can be,
Okay,
your lordship
start.
can decide.
Please start. Abdul
Yes.
Jabbar, who is the
Abdul
father?
father's name Hussain Ali and mother's name Potijan Bibi. Page 15 is the brutal list of 1965.
Just
Page
a minute.
15.
Abdul Jabbar, son of Hussein.
Lordship.
And petitioner number 2, 3, 4, and 5, they are all sons of Abdul
All
Jabbar.
sons of Abdul Jabbar.
So if Abdul Jabbar can prove the citizenship, others will also follow.
Lordship.
Okay, very well. Abdul Jabbar, who is the father?
Page 1515. Brutal
15.
list of 1965. Hussain Ali father.
Hussein Ali is the father.
Potijan Bibi the mother.
Khatijan Bibi is the mother. Which
Next.
document will show Abdul
Lordship,
Jabbar
next.
is the son of Hussein Ali?
Yes. And 1970 also my father's mother's name. 1993. Page
Page.
19.
Page number 19.
Page 19. My mother's, along with my mother's name appeared. Elder
Just a
brother.
minute. What is the village is?
Village.
Borali Mari. Borali Mari. Very well. So now mother is Khatijan.
Khatija,
So Khatija is the mother
mother,
and Jabbar.
Jabbar,
This is the petitioner.
petitioner,
So Jabbar and Abdul Jabbar.
lordships.
Do one thing. We send back, you make a verification as to whether this Jabbar of this one and Abdul Jabbar petitioner, they are the same person.
Yes,
If it is the same person, I think he must have
Yes.
proved it.
yes, Lordship. And present petitioner is of village Sorusola, Lordship.
Sorry.
Present petitioner is of village Sorusola, Lordship.
Now deciding Sorsala, but after 2005, that is upper documents 65, 93.
No. Now they may reside anywhere. If you have any material to show that petitioner Abdul Jabbar and Jabbar of 1993, they are different person,
Yes.
you tell the tribunal, then his case will be rejected.
Yes, Lordship.
If they are the same person, yet establish it through
Yes,
this. If you the petitioner Abdul Jabbar had been referred to the Foreigners Tribunal number
page 40.
Traveler number 5, Morigao, Assam. For rendering an opinion as to whether he is a person who had entered the state of Assam on or after 25/3/1971, resulting in registration of case number FT 319/2016, new number corresponding to FT 1127/12, bracket old number. The tribunal rendered an opinion dated 26/2/2018 declaring the petitioner to be a foreigner. Being aggrieved, this writ petition is instituted. In the writ proceeding, the petitioner relies on the voters list of 1965 of village Boralimari South Part, police station Rupohihat, Moza Ali Tanguni in the Nagaon district, which contains the name of Hussein Ali, son of Abdul Rahman, at serial 431, and that of Khatijan Bibi, wife of Hussein, at serial 432, and both are shown to be residing in the same house number 100. The petitioner also refers to the voters list of, what was the second one?
Second one, 1970.
Page number? No, 70 you did not. 97,
1993, page 19.
page
19.
19. Also refers to the voters list of 1993 of village Boralimari South Part, which contains the name of Khatija, wife of Hussein, at serial 438, and that of Jabbar, son of Hussein, at serial 385. And both are shown to be residing in the same house number 804. It is claimed that Khatija, wife of Hussein, is the Khatijan Bibi, wife of Hussein, of the 1965 voters list, and Jabbar, son of Hussein, of the 1993 voters list, is the writ petitioner proceeding himself. If it can be established that the writ petitioner proceeding Abdul Jabbar and Jabbar, son of Hussein, of the voters list of 1993 are one and the same person, perhaps the petitioner may have discharged the burden under section 9 of the Foreigners Order 1946 to prove that he is a citizen. Full stop. But again, it would depend on the answer to the question as to whether Abdul Jabbar, the writ petitioner, and Jabbar of the 1993 voters list of village Boralimari are one and the same person. For the purpose, remanded back to the tribunal for examining the voters list of 1966 of village Boralimari Part 3 and the voters list of 1993 of village Boralimari South Part, to South Part, and as well as any material that the petitioner may produce that the petitioner Abdul Jabbar and Jabbar of 1992 voters list are one and the same person. The respondents in the Home Department may also make their verification on the aforesaid question as to whether Abdul Jabbar, the writ petitioner, and Jabbar, son of Hussein, of the 1993 voters list are one and the same person. Upon doing the needful, reason order be passed.
Item 14,
One submission, Lordship, page 2005, Abdul Jabbar's name.
It is
That
stated
would be-
that in the voters list of 2005,
2005.
also village Borali Part 2,
Lordship,
it had been clearly stated, it is stated that Abdul Jabbar is the son of Hussein.
yes.
The tribunal may also look into the said aspect.
Oblige.
Shahid Ali, who is the father?
Page 26.
Page 26.
Kurban Ali is the father, 1960.
Qurban Ali Mia, father, son of Muhammad Munsi. Serial 342. This is voters list of which year? 66. Village. Borkolia. What is this? Gola what?
Goldigi.
Huh?
Goldigi.
Sorry.
Goldigi.
Goldigi. Acha, Borkolia Goldigi. Okay, now he is the father.
Yes.
And who, which document will show he is the father?
It's 35.
Page number
35.
34,
5.
35. Qurban Ali, father. And petitioner is
So it does.
Shahid Ali. Shahid Ali, petitioner. Borkolia Goldigi. Voters list of 1989. Okay. Your name?
Is it Ahmed?
Sorry,
Is it Ahmed?
AZ Ahmed. Also, the petitioner Saeed Ali had been referred to the Foreigners Tribunal number 4 Kamrup Metro for rendering opinion as to whether he is a person who entered the state of Assam on or after 1971, resulting in registration of FT case of case number FT bracket G-4 bracket close 371-16. The tribunal rendered an opinion dated witness declaring the petitioner to be a foreigner, being aggrieved district petition is instituted in the proceeding. The petitioner relies on the voters list of 1966 of village Borkolia Goldigi, which contains a name of Qurban Ali Mia, son of Muhammad Munsi at serial 342. Reliance is also placed on the voters list of 1989 of village Borkolia Goldigi, which contains a name of Qurban Ali, son of Muhammad at serial 250, and that of Saeed Ali, son of Qurban at serial 252, and both are shown to be residing in the same house number 281. It is claimed that Saeed Ali of the voters list of 1989, Saeed Ali, son of Qurban, is the petitioner himself. If Saeed Ali of the voters list of 1989 and the writ petitioner proceeded Saeed Ali are one and the same person, the petitioner may have discharged the burden under section 9 of the Foreigners Act in 1946. Accordingly, remanded back to the tribunal to examine as to whether Saeed Ali of the voters list of 1989 and the writ petitioner Saeed Ali are one and the same person. Respondents in the Home Department may also make their own verification and submit a report before the court. The petitioner to also produce the complete voters list of village Borkolia Goldigi from the year 1966 to 1989 for the examination of the tribunal. There is an order.
15,
Other name is Sangsher Ali. Is page 44 man.
Case 44.
Yes. His name appear. In translation code is page 43,
Case 44.
but here page 44 man.
तुम्हारा चेंज पूरी लगा नहीं थी बोलता हो जाएगा तीनटा मान होल्ड देन पाऊंगा
Change.
Case 44 1965
Sangsher Ali is my father.
village is
Sitolmari
colony
Yes, sir.
and Sangsher Ali is the father.
Father.
Which document will show?
Is the
Sangsher Page 60.
The 60 is the voter list.
No, which
Oh,
document will show Sangsher Ali is
But
the father?
I married and Gaubra has examined me. Gaubra issued certificate, he was examined. It is my lord.
How the Gambura came to know?
Yes. His statement is there. my lord.
Gambura, which village?
Of the birthplace.
Huh?
Of that.
Oh,
colony.
Sitolmari.
Yes, my lord. Page 31.
Page 31.
Yes, my lord. I am
That
the-
is Sohirul Islam.
Yes, my lord. I am the Gaubra settlement Patha, settlement colony, Madari, and Swensu. I know the opposite Jamina Khatun of this case. The age of office 60 years. Though he was born.
Just
yeah,
a
settlement
minute. Just a minute. What is the age of the petitioner?
It is a 60, my lord.
Huh?
60. 60.
60.
55.
And he is 55. Gaura's age is 55.
I know. So how does he know?
Hello?
It will even-
Because his brother married her, my lord.
Court brother.
His brother married her, my lord. Gaura's brother,
Sorry.
Gaura's elder brother married her.
Okay. Gaura's elder brother had
Married
married
that
this
petitioner.
lady. Then
It
you give evidence as the. So she is married in the same village.
Same village, same village. And
Then you give evidence as the, this thing, not as a Gaungura.
Hello?
Give evidence
Yes.
as a member of the family, not as Gaungura.
No, guys, a Gaura, he issued certificate, my lord. issue certificate, my lord. This is Gambura. So office married to my elder brother, presently office so I have issued. the certificate.
Mr. Ahmed, we are accepting your evidence not as a Gambura,
Yeah.
but as a person of the
Person,
member
yes.
of the family who knows the fact.
Yes, it may be, my lord. But then, Panchayat also issued the certificate. But
No,
Panchayat
that
secretary not
also
accepted.
we don't give any relevance. We don't recognize this man as the Gambura and his evidence. We recognize his evidence as a member of the family. As a member of the family, he may know the fact.
Yeah. And my lord, if brother also give evidence.
Whose brother?
His younger brother, page 26, my lord.
And how do you know he is the brother?
He stated, my lord.
We don't know. We send it back. We examine this. Third, Mr. J. Ahmed will counsel for the.
And
case.
my name appeared in the voter list of 1993 after marriage. And there is a shifting, my lord. After marriage, from that permanent, we shifted to Bazar.
No, that doesn't matter. If you can establish you are the daughter of Kurban,
Yes.
it is good enough. Mr. J. Ahmed will counsel.
Another point, one certificate, one land document, I annexed here, but it could not be produced there, madam.
Doesn't
There is
matter.
a land, but there father passes a land. and
Whose
below-
father?
uh,
Page number?
Peter's father, page 58, madam,
Page
page 58,
58.
58. His father, her father passes the land at village Khatimudya, near his village, my lord. And after death of father, her name also mutated. Along with other brothers, my lord.
Okay, this is a very good document. This is but this is different village, Hatimuri.
Khatimudya, near, my father passes land at that village.
So how do you know that the Sangshir of Hatimuri and Sangshir of this village are same person?
No, sir, but I may pass land in another village, my lord. That is why that document. Her name
See,
mutated in
Mr.
there of
Ahmed,
1969.
suppose you are the person of X village and you purchase land in Y village and give it to your son or daughter. Your son or daughter to prove that they are the son of J. Ahmed of X village will also have to prove that this J. Ahmed of
Yes.
X village and J. Ahmed of the Y village who purchased land, they are the same person.
No, I will put this into that document.
Yeah, you produce everything. J. Ahmed.
93 Butalis.
I think we have heard you. Let us pass our order. The petitioner Jamina Khatun has been referred to the Foreigners Tribunal number 5, Morigaon, for rendering an opinion as to whether she is a person who entered the state of Assam on or after 25/3/1971, resulting in registration of case number NMFT bracket J 2018/1274. The tribunal rendered an opinion dated 28/11/2018 declaring the petitioner to be a foreigner, being aggrieved the state petition is instituted. In the writ proceeding, the petitioner relies upon the voters list of 1965 of village Sitolmari colony, which contains the name of Sangshir Ali, son of Kobu, at serial 473. It is claimed that Sangshir Ali is the father of the petitioner. Full stop. It is also stated that the petitioner subsequently got married to
To Nurul Islam.
Nurul Islam, also of village Sitolmari colony. And the elder brother of Nurul Islam and the younger brother of Nurul Islam, namely, where is DW2? Page number
That's
DW2,
My lord, page 31.
31,
No, did you look at page 27?
27.
Yes, ma'am.
Namely,
26.
no,
26.
where is the Gambura?
Gambura is page 31.
31.
Yes.
Yes. And if the namely Sahirul Islam, who is also the Gambura of village Chitolmari colony, had deposed before the tribunal that the husband of the petitioner, namely Nurul Islam, is his elder brother, And therefore, he knows the fact that the petitioner is the daughter of Sangsher Ali of the same village. It appears that the DW3 had not been cross-examined by the state authorities. Who is the brother according to you? DW?
Test 22nd, DW2, my lord.
Full stop.
Test 26.
Joinal Abedin, son of Sangsher Ali, had also deposed before the tribunal as DW2, stating that the petitioner Jamina Khatun is his sister and daughter of Sangsher Ali. Is there any voters list of Joinal Abedin and Sangsher together?
No, I am not police. Not exhibited. to
The
the-
petitioner,
Will
in
vote-
order
will
to
vote-
establish that Joinal Abedin is the son of Sangsher Ali, may produce any voters list of village Sitolmari colony in which both the names may appear together. It is also noticed that DW2 had also not been cross-examined by the state authorities. In the circumstance, matter remanded back to the tribunal to enable the state authorities to cross-examine DW2 and DW3. Full stop. If the evidence rendered by DW3 remains unrebutted, comma, it would have to be accepted that the petitioner had discharged the burden under Section 9 of the Foreigners Act 1946 to prove that she is a citizen. Full stop. The state respondent have to make their own verification, submit report before the tribunal. Any reason order to be passed.
And I may be permitted to.
The
examine-
petitioner also relies upon a land document in respect of a plot of land at village
Hatimuri.
Hatimuria, wherein the name of Jamina Khatun had been mutated,
Yes, muted.
mutated in place of Sangsher Ali. But again, it remains for a decision as to whether Sangsher Ali, who purchased land at village Hatimuria, and Sangsher Ali of Sitolmari colony are one and the same person. Petitioner may render all evidence in respect of the same aspect also.
As well as 93 voter list.
Item 16.
Here, my lord. Father's name of the petitioner,
Abdul Nur
Nur
Samad,
Samad.
who is the father?
let Haji Abdul Samad. Haji Abdul Samad,
Abdul Samad. Abdul Nur Samad is the son,
son.
and father is Abdul
Abdul
Samad.
Samad.
Which
So-
page?
Case 23, is anarchy where. Case 23.
Page 53,
23, my lord.
23.
Yes,
Sorry.
NRC, my lord. It is exhibited, exhibit 1,
NRC is not acceptable in evidence.
but it has been exhibited. Then, my lord, village Borbukar is mentioned. Village Borbukar is
But
mentioned.
the material is not admissible in evidence.
Then page 24,
24,
1954 voter list.
54 voters list. Okay. And village Borbukuri.
Borbukar.
Borbukuri 54. Who is A Samad?
A. Samad is my father.
Father.
Yes, Purman Munshi, he is my grandfather.
Is the grandfather. Which
he-
document will show?
He
A
is also
Samad
known
is
as
the
Purman
father.
Munshi, my lord.
Sorry.
He is also known as Purman Ali, my grandfather.
It's okay. Now, which document will show Samad is the father?
My lord, your lordship, can you see, my name for the first time appeared in the voter list of 1997, for the first time. And while I filed a written statement.
What
my
is
lord,
the age of the petitioner?
Now, petitioner is my lord, 42 years,
Huh?
42 years, 19,
42 years. So when was he
45
born?
years.
Huh?
45 years,
When was he born?
77. India, 1977, he born.
1977, he was born.
Born.
So Samad was 75 years.
Yeah, my lord,
When
your
he was
lordship, can you page 74,
Huh?
page 74, my lord. first time my name appeared.
No, this is little strange. Suppose you were born in 1977. Must, ठीक है, recorded in 1997.
97,
It's,
20 years.
That is okay.
Your lordship, I list page 74.
Page 74.
For my lord. Abdul Noor, son of Abdul Samad. Village Borbukuri, my lord.
You produced all the intervening voters list from
My lord,
54 to
whatever.
97.
My all the brother expired. My father expired.
No, no. You produced all the in-between voters list.
My lord.
Hmm.
And my lord, and another thing, my lord, some land documents. Your lordship. I exhibited some land
Page
documents
number,
of my father.
page number.
Page number, your lordship, page number. In this onward 31, my lord, page 31. It is exhibit 6, my lord. Muhammad A. Samad is my father, son of Kurman. Then, my lord, page 33.
Hmm.
A. Samad, son of Kurman. And Soidun Nasa, cell number 7 is my mother. Cell number 7, Soidun Nasa is my mother.
Where is the name of Noor?
Because those land is still there.
No,
But-
no. Where is the name of Noor?
Noor is not there because we could not get mediation because some civil suit is going on, my lord. They obstructed us, my lord. We filed a civil suit.
So
my
then, for our purpose, it is
lord.
not
We
relevant.
exhibited those.
You may have exhibited, but not relevant.
We filed a civil suit. Proceeding is going on, my lord. And
Mr. Ahmed, we are not deciding any civil right.
Madam.
If your Noor name does not appear in the Jamabandi, it is not relevant for our purpose.
Because the result is this.
How can we decide a civil
I
suit
am
now?
not on that. No, just only, my lord, we cannot get mediation because civil suit is pending.
Mr.
And-
Ahmed, it is okay. You get your civil suit decided, you get your name
My lord.
mutated. You
So, my
bring
lord,
it.
I may be permitted to.
For the
exhibit-
time being, it is not accepted.
So I may be permitted to exhibit the voter list of 1997 and other relative documents, my lord.
That is okay.
And I may be
Heard
permitted to
Mr. J. Ahmed, yes. Mr.
exhibit the Gavura,
Mr.
examine the Gavura one. Gavura issue certificate, but not examine one. Because my all other brother died, expired. My father expired, all the brother expired, my lord.
Mr. Ahmed, we cannot allow you to examine the Gambura as a Gambura.
My birthplace.
Ha. If you can say that the Gambura has a personal knowledge of this fact, you examine him,
My lord. My lord.
but not as a Gambura.
Yes, sir.
Gambura may know, he may not know also. Third, Mr. J. Ahmed. If you reject it.
Then thereafter, 2005.
Mr. Ahmed, let us declare the order in your favor. The more foolproof you are trying to make your case,
My lord.
the more weaker it is getting.
My life. Only I shifted to another village, there is a.
Page 28.
Have you completed? Because I don't want to be interrupted in between.
I am completed.
Heard Mr. J. I mean, Abdul Noor Samad had been referred to the Foreigners Tribunal number. Seven. Nogao at Lanka Hujai. For anything an opinion as to whether he is a person who entered the state of Assam on or after 25/3/1971. The resulting in registration of FT stroke L stroke case number 1494 stroke 2018. Tribunal rendered an opinion dated 29/11/2018 declaring the petitioner to be a foreigner, being aggrieved the state petition is instituted in the writ proceeding. The petitioner relies on the voters list of 1954 of village Borpukuri, which contains the name of A. Samad, son of Khurman Munshi at serial 60, and that of Soida Bibi, wife of A. Samad at serial 61, and both are shown to be residing in the same house number 46. It is claimed that A. Samad, son of Khurman Munshi, is the father of the petitioner. The petitioner states that he was born sometime in the year 1977. And accordingly, his name appeared in the voters list of 1997 of village Borpukuri, page number.
Oh, my lord. I'm sorry, my lord.
Page number 73.
$74, my lord.
কি হলো? 1997 of village Borpukuri. The voters list of 1997 of village Borpukuri contains a name of Abdul Noor, son of Abdul Samad, at serial 358. Mr. J. Ahmed, Land Council petitioner, states that all other siblings of the petitioner Abdul Noor had died in the meantime, and even his father Abdul Samad had died sometime in the year
Yeah, 1977, after my birth.
1977, immediately after his birth. To substantiate that, A. Samad of the voters list of A. Samad, father of A. Noor of the voters list of 1997 of village Borpukuri, and A. Samad of the voters list of 1954 of village Borpukuri are one and the same person. All the intervening voters list from 1954 up to 1997 in respect of village Borpukuri may be produced before the tribunal for its examination. The petitioner also relies upon Jamabandi in respect of a plot of land at village Borpukuri, wherein the name of A. Samad had been inherited by some people, but it is stated that the name of the petitioner A. Noor had not been included in the said Jamabandi because of some civil dispute between the parties. From such point of view, till the name of A. Noor would appear in the land documents, we do not see any relevance of such document to establish that petitioner A. Noor, that A. Noor is the son of A. Hamid of the A. Samad of the 1954 voters list. Any other document you have?
The title should, fill of the title.
No, that you do.
There I mentioned my father's name,
Uh-huh.
all the lands.
But however, the
55.
petitioner intends to produce some documents pertaining to the litigation in the civil suit. If so, the petitioner may do so, provided the tribunal shall examine its admissibility in evidence. Any other document? No.
Gabra certificate I will.
Gawra, you produce, how can we permit you? We cannot beforehand permit something which is yet to be done.
Because at that time, the point of time, I am not examined out.
You do, you go. If they refuse, you come
I
back
will.
again. For this purpose, the matter remanded back to tribunal to examine the voters list to be produced by petitioner as indicated above, as well as any further document that the petitioner will produce, and thereafter pass a reasoned order. Again.
My lord, earlier case
The
number.
responding home department may also make their own verification as to whether the petitioner A Noor is the son of A Samad of the voters list of 1954 of village board and submit the report before the-
My lord, in earlier case number is 135 public 2009. Earlier, application number.
What are you?
It may be wrongly, I think. Application number FTD 135 2015.
Item 18,
The name of the parents of the petitioner is in the voter list of 1966 as well as 1970 of the lordship.
Page number?
Page number 66 at page 25 and 26, your lordship.
25 and 26.
Sabir Ali and Moijan Nessa is the father and mother of the petitioner. And at page 27 and 28, there also the name of the parents is available. And
Saber Ali is the father,
lordship,
and which material will show is the father?
Moijan Nessa is mother. And the
No, which document will show that he is the
lordship,
father?
the 1997 voter list. The name of the petitioner as well as the parents
Page number.
is at page 29 and 30. 29. Sabir Ali,
Saber Ali is the father, no?
father,
And
Moijan Nessa
petitioner is,
mother,
petitioner is
petitioner is
Zulas.
Zulhas Mia. At serial 308.
Yes, Mr. Sharma.
Remand the matter of present.
Heard Mr.
As you say.
S. Hussain and counsel for the petitioner also heard the petitioner Julas Mia had been referred to the foreigners tribunal number
10.
10 Borpeta for rendering opinion as to whether he is a person who entered the state of Assam on or after 25/3/1971, resulting in registration of FT case number 5/2016. The tribunal rendered an opinion dated 8/2/2018 declaring the petitioner to be a foreigner, being aggrieved the said petition is instituted in the writ proceeding. The petitioner relies upon the voters list of 1966 of village Doboliapara, police station Borpeta, Mosaic Hilajari in the present Borpeta district, which contains the name of Saber Ali, son of Ali Sheikh at serial 572 and that of Moijan Nessa, wife of Saber Ali at serial 573. Both are shown to be residing in the same house number 171. It is claimed that Saber Ali is the father of the petitioner and Moijan Nessa is the mother of the petitioner. To substantiate the claim, reliance is placed on the voters list of 1997, also of village Doboliapara, which contains the name of Saber Ali, son of Ali at serial 275, and that of Moijan Nessa, wife of Saber at serial 305, and Julhas Mia, son of Saber at serial 308, and all are shown to be Mr. Your name? Hussain.
Hussain.
Page 29. Come to page 29.
Lordship.
I think you have wrongly typed. Just look at that column number 1 and column number 2. Check up with the vernacular. 275 must be the house number, 304 must be the serial number.
Lordship.
Where is
Serial number is 304. And house number is 2.
Yes, Lordship. Wrongly.
This is house number.
Nine.
Look
Yeah.
at it properly and then make your submission.
Here is number 1 is serial number. And the number 2 is house number. columns 2.
Do you think the information typed out is right
I
or
think
there is some wrong typing?
maybe.
Check up.
Another aspect is, Your Lordship, this 35.
Coming to
Lordship, yes, in particular, in Lordship,
045 again serial number
in
275.
particular,
the house
that is
number.
difference, Your Lordship.
Look at page 30 and page
Lordship, I
29.
have seen, yes, Your Lordship.
Do you think your typing is right?
No, sir.
No. Correct it.
Lordship.
Keep a look.
Also, Lordship, he is of village Joypur, Lordship, but document placed.
997, which contains the name of Saber Ali, son of Ali at serial 304, and that of Moijan Nessa, wife of Saber at serial 305, and Julhas Mia, son of Saber at serial 308, where all of them are shown to be residing in the same house number 275. As the name of Julhas Ali, son of Saber, and Saber Ali, son of Ali appear in the same voters list, and all both are shown to be residing in the same house number, and the name of Saber Ali, son of Ali Sheikh, appears in the voters list of 1966 of the same village. It is claimed that the burden under Section 9 of the Foreigners Act 1946 had been discharged by the petitioner to prove that he is a citizen. In view of the above, remanded back to the tribunal to examine the voters list of 1966 and 1997 of village Doboliapara, which contains the information as indicated above, and thereafter pass a reasoned order. The petitioner to also produce all the intervenings and complete voters list of village Doboliapara from the year 1966 to 1997 for the examination of the tribunal, upon which the needful reasonable. Respondents may make their own verification, and also as to whether Julhas Mia of the 1997 voters list and the writ petitioner Julhas Mia are one and the same person.
Highly obliged.
19 and 20, Lordship, I need.
19 and 20.
19 and 20 unit time.
Yes, Lordship. to
Adjourn
file
on the prayer of Mr. G. Sharma, learned counsel for the Home Department. He needs time. How much time you want?
1 week, Lordship. I have to file the affidavit, Lordship.
তাৰপিছত কি আছে সেইকেইটা কৰি লওঁ
Item 26 to 29. Item 26 to 28.
Who is appearing for the state?
Tina,
Where is he?
Civil income.
He
He will come, my love. He will come, my love.
He will come.
My love.
Now what do we do?
If petitioner makes submissions, if any, my love,
Petitioner, no, entire record has to be produced. That's all. Then only we proceed. Correct. 2109 for like 2108. Correct. Delta. Be little more careful. It is their work to verify the numerical security. Correctly, we cannot. And we have to call for the file. Hmm. Hmm. That's a decision. Yes, where are the, you have it with you?
My lord, I have no instruction, my lord.
Pick up after some time, let him
Yes,
come.
my lord. Oblige.
Item 29,
What is this IA for? Correction?
My lord, this not really correction, my lord, will be modification, my lord. We have challenged the, my lord, proceeding pending before the tribunal, my lord.
IA?
And your lordship, my lord, passed for, this all court, my
No,
lord.
no,
passed-
why is this IA file?
I am, my lord, lordship and
Modification
lordship.
of
Lordship
the
and
order dated, so it's a writ petition order, how can it be modified?
writ petition is pending, my lord.
Huh?
Writ petition is pending.
Then what was this order?
Page 11, lordship, we have annexed the order.
What kind of modification you want?
My lord, the proceeding is pending before the landed tribunal. We
Ah.
challenge the proceeding, my lord.
Uh-huh.
And your lordship granted bail and other condition, my lord.
So,
And I have not declared as foreigner there. So our.
I
our- Our.
heard Mr. R. Ali, learned counsel for the petitioner. By this indication, certain modifications are sought for in the order dated 9/5/2023 in WPC 2370/2023. In view of the submissions made, the order dated 9/5/2023 is recalled. WPC 2370/2023 to be listed for its consideration. I allowed.
Further proceeding.
We don't
Stay, my lord, then it will be.
We cannot modify. We recall that order, we'll hear the writ petition.
My lord, the writ petition
If you
will-
feel that order is wrong, we have recalled that order. That's all.
Order will not be applicable, my lord, in our case. So. my
No,
lord,
no. We have recalled the entire order. We cannot recall in part. And we list the writ petition.
For,
And on that day, you make your submission, what order you want. I allow.
my lord, in the tribunal, my lord, matter is 17. May I pray?
No,
my
no,
lord?
this should be listed now.
Oh.
We have to list the writ petition. We'll
Oh.
list it. तो हुनकाले लगी जल्दी दीजिए, निकालो.
All right.
And Mr. Ali, Lordship is rightly pointing out, this was dictated in the open court in your presence,
My lord, your lordship, my lord.
whatever it is. Then you ought to have pointed out then and there.
No, this whole court, my lord, passed interim order. That's.
Very well. No, you should have pointed out
Lordship.
that I want a different kind of a order, not that one. What prevented you from pointing out? It will detail this to her. We'll see when it's
Lordship.
raised again.
Lord.
for admission item 21 to 25.
Please, your lordship, my lord. My lord, by virtue of my lord, second, my lord, proceeding, my lord. I was taken into custody, my lord. I was issued with a notice, my lord. The subsequent occasion, my lord. And in the first proceeding, my lord, I was declared to be a foreigner. That was put to challenge, my lord, before this honorable court, my lord. And that writ petition was dismissed in the year 2018, my lord.
In
Thereafter,
the first proceeding, you were declared as foreigner.
my lord,
High Court dismissed your writ petition.
my lord.
And then after that, what happened?
Thereafter, my lord, a second notice was issued.
So second notice will interfere.
Yes, my lord, that was put to challenge before this honorable court.
We will interfere with the second notice. No difficulty with that.
My lord, kindly have a look at the notice and the
No, we'll interfere with the entire second process.
My lord, what happened in this case, my lord? The day of my first appearance in the second notice, my lord.
Mr. Hamad, don't worry about the second proceeding, it will be interfered. Okay,
I'm in the judicial custody now.
Ah,
Since
you'll be in custody pursuant to the first proceeding where you were declared.
Yes, yes, Lordship.
You were declared to be a foreigner in the first proceeding.
yes, my lord, but as per the my lord order of the second my lord proceeding, my lord.
Mr.
second-
Hamad, we have told you, we are interfering with the entire second proceeding.
my lord.
So you don't have to make part submissions on that. But against your detention, it will be as per the first decision.
Yeah.
By which you were declared to be a foreigner.
Right.
So now we'll determine the rights of this person as a foreigner. Yes.
May I produce one, my lord? Order is there, my lord, the departmental order, my lord. If your lordship permits me, my lord,
What kind of department?
there is a confidential order, my lord. That has
Mhm.
been passed by the my lord Deputy Secretary to the government of Assam.
What kind of order the deputy secretary is?
Thank you, sir.
Hmm. 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 How does it matter?
So as per this, my lord, confidential order, my lord.
A deputy secretary cannot determine the court proceedings.
Yes, my lord. What I'm trying
Let
to
the
say,
deputy secretary do his own work. We are not concerned.
my lord.
We are determining once a person is declared citizen and foreigner,
Right.
what are the legal rights that will remain with him? What are the legal rights that will not remain with him?
Yes, my lord.
And we are determining it.
What I'm trying to submit before your lordship. is
This
that
is of no relevance for us.
regarding the my lord, taking the detention of a my lord proceeding, my lord. As per this order, my lord, it
So
debarks.
do you mean to say that the deputy commissioner, the secretary has determined that whosoever is declared to be a foreigner, he'll be entitled to everything?
No, my lord.
Are you trying to suggest that?
No, my lord. My lord, it debars a member of a tribunal to take into custody, my lord.
Doesn't matter. You have to follow the law with determining the law. And this is a 226 court, mind you. This is not a tribunal. Please take note of that. Where we are here to determine the legal rights of the persons. And who is this Parijat Bhuiya, SCS Deputy Secretary, Political B?
Lordship, he is in,
Sorry.
yes, Lordship, he is deputy secretary.
Ask this person to remain personally present. What it exactly means, we want to understand. Call her.
Yes, Lordship.
And also ask the judicial department to remain present. We are taking up right now at 2 o'clock.
At 2 o'clock.
This is something half-baked.
Yes,
If you feel the tribunals are not to give pass this kind of orders, then you have to also state that who will pass the order. Otherwise, you are giving a free hand to the foreigners. What authority they have to do that? To create a confusion for nothing. Let the judicial department also remain present. Appropriate, one of the higher authority of the judicial department. Oh. Okay. আপনি continue করবো বলে, এটা দেখে বলছি। ওকে ঠিক খোলা হলে বলছি না।
Tomorrow or today?
Today? 3 o'clock. Now, we want to understand the meaning of this one. What do they mean by it? It's neither here nor there. Noted that consequence or deletion of this may not be necessary. Then what is necessary? And why are you saying so? So are they trying to interfere with the judicial process of the tribunal?
Let him present, let her present.
Noted that the consular deportation, this may not be the correct approach. Then what is the correct approach? And who will determine the correct approach? And have they determined any correct approach? Tribunals are entrusted with the jurisdiction to render an opinion whether the person is a citizen or not. Along with it, they are also expressing the view what is to be done.
Yes, yes.
So now, if tribunals are not to do it, who is to do it? Or it will remain in a vacuum? I don't understand. Okay. Yes.
Section 3 बोले then the government will decide nothing. Can I start? Section 3 sir.
Yes.
Yes, next one. 22. You want to say, you try to say that your case is different.
Yes, madam. My question.
In what manner it is different?
My lord, Lordship may kindly see page 21. My father name appeared in the voter list 1966. Alimuddin. Muhammad Ali.
WPC 7156.
Yes, madam. Since 1966, father name appeared, my lord, in the voter list.
19,
66, my lord.
page number,
Page 21, my lord. Vernacular is page 22.
page 21.
My lord, Abdul Bari is my father.
Angbari is the father,
Father, yes, my lord.
66.
Yes, sir. Is it
Angbari,
Gao, Paschim
Angbari
Jamuna?
father, village, Paschim Jamuna Gaon.
Lordship,
Now, who is the petitioner? Alimuddin.
Muhammad Ali Muddin.
Which document will show Alimuddin is the son of Angbari?
Lordship, may kindly see page 31, my lord.
31.
Same village, my lord.
Alimuddin, son of Abdul Bari.
Bari.
Yes.
There's the subsequent voter list, my lord.
No, anything in between? No.
Yes, my lord, 1970 also, my lord.
Page number,
Lordship, may kindly see 70, page number 25, my lord.
page number 25. Angbari, son of Hanif, same thing. No,
Same.
it's 85. Page number 25 is 85.
85, yes, lord. Another 1970 also, my lord.
Yes, Mr. Sharma. You examine this whether it's the same or not. You're sending it back. Third mist, no?
1966 voter list is of village Jamuna Gao. Again, 1966 lordship, two voter list lordship. Yes. It is, one is of Pub Jamuna and one is of Paschim Jamuna Gao. That is my maternal grandfather, my lord.
Just a minute. 1966 is Angbari. Angbari is the father or grandfather?
Father,
Angbari is the father.
Abdul Bari is the father, son of Hanif.
Yeah, what the grandfather will be received.
My lord, my father name and my paternal grandfather name is same.
Paternal grandfather.
Grandfather, yes. That's why
No,
another
this Angbari is the grandfather or father?
father.
Then who is the grandfather?
My lord, Abdul Bari Laskar.
No, Angbari is the son of Hanif Mia.
Yes,
So grandfather must be Hanif Mia.
my maternal, from my maternal side, my lord.
Maternal side, from your mother's side.
Mother side. My mother, husband name and father name are same.
Where does the name of your maternal grandfather appear?
Lordship, another voter list, lordship may kindly see
Page
page
number?
19.
19.
19, yes. This is from Pub Jamuna Gao, my lord.
Achha, this Angbari or son of Askar is your maternal grandfather.
Yes, lord.
Means his daughter was married by Angbari of the 19 of Paschim Jamuna Gaon.
That's why two voter list.
Jiuddin.
Lordship.
Heard Mr. Jiuddin and counsel for the petitioner also. The petitioner Alimuddin had been referred to the Foreign Tribunal number.
Lordship, tribunal.
Foreign Tribunal number 10 Nagaon at Hangardev Nagar Hojai for rendering an opinion as to whether he is a person who entered the state of Assam on or after 25/3/1971, resulting in registration of which case?
My lord, registration. It's lordship.
Registration of FTD case number
Case number
16667/2017. Why three cases are decided together?
It is earlier clubbed together, my lord.
Now, how can they club?
That's.
Yes, Mr. Sharma. How can the tribunal club matters? The jurisdiction given is SP will refer a matter whether the man is a foreigner or not. How can you club? X may be a foreigner, Y may not be a foreigner. But if you club them together, what will you do? Even if they are brothers of the same family, still it will be two different proceedings. There is no question of any clubbing. So now if I interfere with this order, what will happen to the other two orders?
My lord, that's why all are all together, my lord.
Sorry.
One writ petition number 7005 oblique 2017.
No, we understand that. Suppose as the tribunal had decided three FT cases together and all are having same number. No, different number.
Different number.
So now I'm interfering with the order in respect of one of them. What will happen to the other? Yes. Sharma, these tribunals, we are unable to understand what kind of procedure they are adopting. And difficulty is everybody is having their own different concepts, different procedure. It's not one homogeneous thing called foreign tribunal. Not only that, if you notice, even the manner of writing the case number is also different. Every member will devise his own way how to write the case number. Why can't you bring in some uniformity in their procedure? Now, what we are supposed to do with this order? Because we intend to interfere in his favor now. Now, what do we do with it? Will the order in respect of all that we reference should go? Sorry.
Reference is separate.
Separate order.
This is reference 1167. This petitioner is 1667, my lord.
We understand, but it's a common judgment and order. So if I interfere with this order in respect of the other cases will also go.
Another case, next one.
Can it be lordship tomorrow or day after tomorrow, lordship? I want to see it.
Ask this Mr. N. Jha, member Foreigners Tribunal, why he had done so. If there are three reference, there will be three cases registered, there will be three judgments.
Yes.
Judgments, purport of the judgment may be same.
Yes.
Language of the judgment also may be same, but it has to be three different judgments. But now by making one common judgment, if we interfere in respect of one of the reference, what will happen to the other two? And secondly, how we decide that? Now, suppose we are deciding about the other two, they are not before us in this case. Suppose three different writ petitions have been filed. Now we are required to club three different writ petitions, which otherwise you would have decided individually because of this conduct of the tribunal. We do one thing. We pass a simple order, set aside this, it cannot be one to decide all the three cases individually. What else?
Yes, Lord.
Go back, he will discharge his burden.
Yes.
We are not observing anything on merit. He'll issue fresh notice to all the proceedings in all the three petitions. Ask them to come and he'll decide it separately.
Yes.
And if the proceedings intend to rely on any material already produced, they will be free to do so.
Yes.
has writ petitions been filed by the other three proceedings?
Yes, my lord. Here, next one is another one.
Next item, today itself.
Today,
And the third one?
another is, my lord, your lordship already passed an order regarding this issue of Gabura certificate regarding discrepancy.
No, that means that is already allowed.
Mother, my lord, that was in respect of the mother of this
No,
petitioner.
no. Regarding this common judgment, did we pass any order?
No,
What happened to the third case then?
had lordship, it was earlier with this case, my lord, along with this case, and lordship
Hmm,
separated it, my lord. WPC number 7005 of 2017. Which is fixed on 18 minor, all lordship are fixed in 18 minor.
It is noticed that the tribunal had clubbed three references, being FTD case number 1666 2017, FTD case number 1662 2017, and FTD case number 1667 2017 together, and had passed the common judgment and order date 30/10/2017. This writ petition is instituted in respect of the common judgment and order in respect of FTD case number 1667 2017. It is stated that WPC 7160/2017 is against the common judgment and order in respect of FTD case number 1662 2017. And another writ petition, WPC
My lord, 7005.
7005 is in respect of FTD case number 1666 2017. The three writ petitions, tinta number present to 7160 and 7. We listed together on
My
18.
lord, 18 fix this
So
7005.
these two also we are listing on 18. We are going to set aside the common judgment without giving any reason that it cannot be done. The tribunal will decide the matter individually of all the three cases. It will be the notice of common very daily. Investigation, basically, investigation dependent upon. 80. We ordered some investigation, inquiry,
Regarding my lord voter list, in this case,
some certificate.
not my certificate, my lord. Gabura certificate is
We'll look into the aspect of the investigation.
lordship.
Whichever way it goes, it will be against those person issuing the certificate, nothing to do with the petitioners.
Lordship.
For the petitioners, we'll set aside the common judgment. Send it back that they decided individually.
That will be better.
Otherwise, how can you determine? One may be, one may, other one may not
Yes,
be.
my lord, there's some complication there.
All are family members.
Sorry.
All are family members. Lordship.
In fact, in a situation where we are asking the writ petitioners to file separate writ petitions,
Yes.
tribunal is following the reverse trend. Getting lash of some similarity here and there, they're trying to club and give a common judgment. They cannot do it. Every individual person referred, he will be decided individually whether he's a citizen or he's not a citizen. And that individual person will be free to produce any material he wants to produce to prove his citizenship.
Hello. In the Pathad matter,
Hmm.
Madam Ghosh is leading the argument. She has requested for an accommodation post lunch.
When the leader is absent, the second in person takes over.
My lord,
That's a rule everywhere.
at 2 p.m., my lord, just 5 minutes remaining. My lord.
Mhm. 5 minutes is also some time.
My lord, I can start.
Mr. Mahmood, you'll have to wait for Mr. Nath.
Perhaps I think it should be kept
Sorry,
2 p.m. will be better because time is very only 5-6 minutes.
for you, yes, not for Mr. Awan. Yes.
My lord.
It would actually be.
My lord, the learned counsel for the state and the union refer to Assam Alienation of Land Regulation Act 1980. And it was argued, my lord. It was argued, my lord, that if there is any transaction of the land by the declared foreign national, then that will be null and void from the day of the transaction that has been made. My lord, I would like to take your lordship through section 13 of the Assam Alienation of Land Regulation Act 1980, my lord. 1980,
Alienation of land.
Assam Alienation of Land Regulation Act 1980.
That's not, individually disabled, he covers disabled. Print out this. Print out the two.
The last page of the printout, my lord. Section 13. The last para, my lord. May I read, my lord? Lord, it says the Assam Alienation of Land Regulation Ordinance 1980 is hereby repealed. Notwithstanding such repeal, anything done or any action taken under the said ordinance shall be deemed to have been done or taken under this act if this act had come into force on the 7th day of April 1980. So, my
But
lord,
this is a saving clause.
my lord,
It's a saving clause that as the earlier act is repealed and the new act has been enacted in its place, whatever was done under the earlier act will be saved.
my lord.
Was something done under the earlier act in respect of these people?
My lord, so my humble submission is, my lord, that if there is any transaction before this, the inception of this act, my lord,
Sorry.
if there is any transaction that has happened before coming of this
No,
act,
no, that proximity of the transaction will depend on interpreting the law of declaring a person to be a foreigner. It cannot be that when I was not declared to be a foreigner, the law permitted.
my lord, but if there is any substantive right which is involved, my lord,
No, no, now notwithstanding, sir, anything done or any action taken under the said ordinance.
my lord,
You first show us what is that ordinance? 1980, 1890. No, 1980, and then show us what action had been taken. Action taken is always pursuant to some provision of that act. Show us. Purchasing a land is not an action under that ordinance.
But my submission.
Mr. Rama, purchasing a plot of land prior to this act is not an action under the ordinance of 1890. Action under the ordinance of 1890 will be under some relevant provisions of that ordinance. Something must have been done by the authorities.
But that also means that this act cannot be.
No, you cannot forcefully give a meaning to something. Just because that forceful meaning is in my favor, so I'm trying to give, you cannot do that.
Not at all, my lord.
We have to follow the law.
My lord.
This law says that anything done or any action taken under the ordinance of 1980 shall be deemed to have been done under this regulation. That's all. That means it is giving a continuity. So this argument goes against you. It gives a continuity as if it is done under this act. So ultimately, this act is applicable. This act is applicable in respect of those acts done under this act. It is also applicable in respect of those acts done under the 1980 ordinance.
My lord.
So the basic direction of your argument is it's against you.
But I would like to take you through one judgment. my lord.
The judgments can come later. First, you have to understand the law. Then only the judgment will come. We are having difficulty in accepting what you are trying to argue, because it will be against the principles of law as well as the interpreting the law.
My lord, what I'm trying to say is that
Sorry.
this act should not have any retrospective effect, my lord.
No, this one is giving it retrospective effect. That's why I'm saying the provisions of section 13 is directly in contradictory to what you are trying to extract out of section 13. Section 13 says action can be taken under this act, action can be taken under the previous ordinance. Section 13 makes it whatever action was taken under the previous ordinance will now be deemed, a legal fiction is created that as if it is done under this act now. So that is going against you.
My next part of the argument is this judgment will explain, my lord, that whenever there is a substantive right involved, my lord.
So what is the judgment? Judgment on what point?
This is, my lord, Hitendra Vishnu Thakur, of the state of Maharashtra. This
No,
is
that's okay. What is the legal proposition laid down there?
that whenever there is a substantive right involved,
Sorry.
any action which impact the substantive right of an individual, that in that case, my lord, the act should not be read into retrospective manner, my lord. It should not have any
No, we
retrospective
have
effect.
understood. If any, what happens?
My lord, it says, I will try to read, my lord,
Para 25.
para 25, my lord.
So if para 25 is in your favor, you'll have to challenge section 13. Saying that section 13 of this act is maybe contrary to para 25 of the judgment of the Supreme Court. This is not only doing it, this is why you were saying it is against you. It says, suppose somebody's land is taken away under the ordinance and the act ordinance is repealed by this act. Section 13 says that that act of taking away the property under the ordinance will now be deemed as if it is done under this act. So that action is saved. Not that the action is vitiated. So now if you say that the act of purchasing a land prior to this act is an act done under the ordinance, that act is now deemed as if it is done under this act. As a consequence, if this act is prohibiting some kind of a acquisition of that property, that prohibition will be applicable even to that. So that's why you were indicating 13 is against you.
I stand corrected.
Understood? Hmm? And this is a judgment on Tada. Tada is a criminal act. Criminal act, mainly what happens, every procedure, every offense that is made out in a criminal act is always with prospectivity. Because suppose today in 2023, a criminal act is enacted, which will make a particular act to be an offense. That act was performed by you prior to the act being enacted. As on that day, it was not an offense. So this is the meaning of para 25. Suppose stealing a pen is an offense from today, and you stole the pen yesterday. You cannot be held liable because you had stolen it yesterday. Yesterday, stealing a pen was not an offense. Only from today it is an offense. This is the what 25(6) provide for. But here we are not dealing with any criminal act. 13 says it is deemed as if it is done under this act. So the jurisdiction of this act is also extended in respect of the acts performed. We'll come back at 2. We'll hear it. Are you clear?
Hello.
If you want to prepare, you prepare.
Post lunch.
If you want to say something else.
Keep your plate.
Yes.
My lord.
You want to continue, or you said Madam Ghosh will be coming at 2?
Yes, yes, my lord.
Where is she?
He is yet to come, my lord. On her way, my lord.
Do you have something more to say, or
Yes, sir.
you just want to take the time till Madam Ghosh comes?
No, no, my lord. I have started my argument, sir.
This is one we understood. Next one.
Lord, so on this, my only humble submission is that any transaction that happened before this act or this ordinance.
No, we have heard you.
Hello.
I don't think that is an acceptable submission.
My lord. So my next, my lord, I would like to take your lordship through section 6, my lord, of
Of
this
the-
Assam, the same act, the Land Alienation Act.
Any alienation made.
My lord, any alienation of any land made in contribution of the provision of section 4 shall be void and of no effect, and the land alienation shall vest in the state government from the date of the alienation, free from all encumbrances. That number 2, my lord, subsection 2, my lord,
Hmm.
that the collector may, after giving the parties an opportunity of being heard. But here my humble submission is that, my lord, this should be decided on case to case basis. When an alienation happened,
Mr. The law is different. Implementing the law is different. When the law will be implemented, it will be case to case basis. But law cannot be decided on case to case basis. Because law is universally applicable to all.
that is correct.
So when we are interpreting a particular provision of a law
My lord.
on its applicability, that cannot be case to case basis. But when that interpreted law is being implemented
My lord.
in respect of various persons,
I know.
that will be definitely on case to case basis.
But if it is vested on the government, if the alienated land vested on the government, that should happen So my respectful submission on case to case basis, my lord.
That is what we are saying,
My lord,
implementing.
my lord,
When this law will be implemented,
my lord.
definitely.
Also, my lord,
Whether your land is to be taken or Mr. Mahmood's land is to be taken,
my lord.
that will be case to case basis. Your land may be taken, Mr. Mahmood's land may not be taken.
I know.
But to understand the law and its applicability in respect of a class of people, that cannot be case to case basis. So here what we are deciding is on the applicability of the law. That's all.
Also, my lord, this provision should not.
And moment we declare that this law will be applicable to a particular class of people, definitely section 6 will be applicable when it will be implemented.
My lord,
There is no doubt about it. They cannot do it without following section 6.
my lord. Also, my lord, this act, entire act should be applicable on declared foreign nationals only when there is a judicial confirmation, my lord. Because
Definitely.
One,
We are deciding the effect only after there is a judicial declaration.
till the time the declared foreign.
Mr. Aman, our entire endeavor in these proceedings is what are the rights that will remain and what are the rights that will not be available once a person is declared to be a foreigner. So you need not go to this question that it will be applicable only to a declared foreigner. Definitely only to a declared foreigner.
What I was trying to say, your lordship, that when a person is declared a foreigner by the tribunal, so he has an opportunity to come under 226 and then to go to the Supreme Court, my lord.
That the law will follow. See, once a man is convicted of 302, does the sentence start then and thereof, or it is stayed, or it is because an appeal is filed, or it is not stayed? That depends on what the higher forum does. That cannot have any relevance for our purpose.
But when a land is taken away, my lord, and that person is again declared as a Indian by this honorable court, so that process should.
Mr. Aman, you are imagining something which is yet to take place, and everything will be within the four corners of law.
My lord,
Whatever the law provides, that will be applicable.
is your lordship.
And there cannot be a situation that I envisage a very serious situation, therefore the law will not be applicable.
My lord.
It cannot be like that.
My lord. Also, my lord, FEMA, the Learned Council for the State and the Union also argued that FEMA should be invoked here. And they also refer to this 2018 FEMA regulation. So, my lord, first, if your lordship allows me to take you through this definition of the person resident in India, my lord. FEMA.
I will note. This.
Here, right? This
Yeah.
is the FEMA regulation.
Oh,
This is the FEMA regulation.
Who argued FEMA?
I think both the council, learned councils, the learned council for the state,
Mr. Nath,
Mr. Mazumdar.
Mr. Mojumdar.
My lord. Regulation act.
You referred to only certain adjustments.
Here.
No, it's, we did not take note of any FEMA. Anyway, FEMA, what is it?
My lord, that the printout that I have shared with your lordship, I'm sorry, I did not get the barrack. I had to take the print.
Okay.
My lord, the second last page of this
Uh,
print, my lord, second last page,
uh.
which is section 2, Roman 5. My lord.
And what was the argument on FEMA?
Basically, my lord, that FEMA should be attracted and the transaction with regard to
Oh,
resident of,
was it argued in detail? Because we did not take any note.
my lord, then,
Because a lot of casual statements were made here and there. Every statement I have not taken note of.
I'm
Unless something is seriously and argued in detail. So that we have to answer.
my lord. That I'm not rebutting, my lord.
Hmm. Hmm. ये रिजर्व बैंक को ही कौन सा नोटिफिकेशन को रिजर्व बैंक को नोटिफिकेशन
Lord, I'm not referring to that.
which one FEMA
The FEMA, my lord.
no anyway what was the argument
My argument is, my lord,
no not yours
that
their
there was a regulation of 2018, my lord. That regulation apparently says that there was a FAQ where it-
that's the reserve bank FAQ
my lord, purchase of the immovable property stated that whether a foreign national can acquire property in India. And it says that citizen of Pakistan, Bangladesh, Sri Lanka, Afghanistan, China, Iran, Bhutan, Macau, Hong Kong, or Democratic Republic of Korea, irrespective of their residential status, cannot, without prior permission of the Reserve Bank, acquire or transfer immovable property in India, other than on lease, not exceeding 5 years.
yeah very well now
No, my lord, here, the DFNs, my lord, are not
sorry
the declared foreign nationals, my lord. They are not citizens of Bangladesh, my lord. Because their determination of nationality is not being done. It's just a.
no they came from declaration is they came from a specified territory
My lord,
entered Assam
I know.
prior to 25/3/1971
my lord. So that determination, my lord, done under section.
so where is the specified territory located wherever it is located that is the country specified territory is defined in the act and the provisions. So therefore, if specified territory is Bangladesh, Bangladesh is included.
But the order.
It doesn't matter whether Bangladesh accepts them to be or not. There is a declaration that they came from the specified territory. And wherever is the specified territory located, they are from that place. So from that point of view, why we can't say that the Indian law will not be applicable because another country doesn't accept them to be their citizen.
You know, that
And any person being a citizen of Pakistan, Bangladesh, Sri Lanka, so and so, so and so, so and so, including having a place in business in a manner permissible, will not be permitted to acquire or transfer any immovable property in India in the individual capacity without prior approval of the RBI. If RBI approves, they can.
my lord.
This is what FEMA says. And this is for the purpose of foreign exchange. These illegal migrants declared foreigners, they are never going to purchase any property with where foreign exchange will be involved. And so from that point of view also, it's not much of a relevance. Are they purchasing property with Bangladesh currency? No. They purchase with Indian currencies. So this is the control of Foreign Exchange Management Act. Therefore, the Reserve Bank had put in certain restrictions that it will be only after their approval because the question of foreign exchange, foreign currency being involved in those transactions. That's the purpose for this one. It's not an absolute prohibition. It's not an absolute prohibition. But where is the other one, that alienation act, that is a prohibition,
My lord.
if it is applicable. So you can argue on the applicability or non-applicability of that alienation act.
My lord.
Revolution. No. Hmm. Yes.
My lord, also, my lord, it was argued, my lord, that the declared foreign national, my lord, are enemy aliens, my lord. Now, the term enemy is defined in the Defense of India Act 1962.
Yes.
My lord, this is the fourth page, my lord, that the Defense of India Act, section 2, subsection C, my lord. In the fourth page, First
Ah,
line.
enemy, yes.
Enemy means, may I read your lordship?
Hmm.
Enemy means any person or country committing external aggression against India, any person belonging to country committing such aggression, such other country as may be declared by the central government to be assisting the country committing such aggression, any person belonging to such other country. Now, my lord, this term, external aggression, came up in Sarbandu Sonwal, my lord. But in the Assam Sanmalita, my lord, where some 13 issues were framed, this is one of the issues which has been referred to the larger bench,
Let us take a look at it.
Sanmalita, my lord. This is 12,
Hmm.
2014, my lord. Assam Sanmalita.
Which paragraph?
My lord, 33, 4. Roman four,
Paragraph 33,
my lord,
4.
4,
33, 4.
Roman 4, my lord. SCC, my lord.
Coming now to the merits, we have heard several counsel for the petitioners who have raised a number of points which have been rebutted by the counsel for Union.
My lord, this is Assam
We
Sanmalita,
feel
my lord.
that the following question need to be answered by an appropriate bench, as most of them are substantial question refer to the interpretation of constitution, which have to be decided by a minimum of 5 judges under. Now which one?
Number 4, my lord.
Whether section E violates article 3, what is the true interpretation of 355? Would an influx of illegal migrants into a state of India constitute external aggression or internal disturbance? Does the state occurring in this article? And this is a judgment dated
1712, my lord.
17/12,
2014,
2014.
my lord.
Very well.
So the constitution bench is hearing.
So
the matter.
now it would have to be some benches hearing this
My lord,
question.
my lord.
What is the status of that hearing?
Hearing is going on, my lord.
No, what is the present status? Which case number?
This is 562.
Hmm.
Yes.
Find out the status from the Supreme Court website. What is the last order passed? Right? Hmm. এইটো, সম্পূৰ্ণ হ'ব পাৰে, নহলে আহিলে হয় কেতিয়াবা। Now, what is provided in that Sarvananda Sonwal?
My lord, it regarded the entire thing as external aggression.
So now how do you reconcile the two?
Now that because the larger bench is hearing.
No,
the-
no, how do you reconcile the two? If Sarvananda Sonwal had decided the issue,
My lord,
then no reference is, Sarvananda Sonwal is dated 12 July 2005.
My lord.
This one is dated
This is 17/12/2014.
7/2014, yes.
But this, the Honorable Supreme.
No,
Court-
no,
My lord.
but does Sarvananda Sonwal is by a bench of 1, 2, 3 judges.
3, my lord, 3, my lord.
So this is
5.
by 2 judges. This order
My lord, this order is 2
by
judges.
2
My
judges.
lord.
Did the 2 judges take note of what has been decided in Sarvananda Sonwal?
No, my lord, my humble.
So even if it is per inquirium. So this will be prevailing the law. And if constitution bench had been constituted and it is decided and it decided in a reverse different manner, then from that day it will be applicable. But till constitution bench decides, Sarvananda Sonwal will be holding the field.
My respectful. submission.
You're respectfully, you are saying no, but how, on which principle? If you say so by referring to a two judge order saying that this requires constitution.
Yeah.
Sarvananda Sonwal had taken a totally different view and had explained the circumstance in a more detail. Then what do we do? Can the High Court say we are closing our eyes to Sarvananda Sonwal?
My lord,
Can you do it? Can we do it?
but also.
Just say
there is
yes
a
or no.
5 judges bench, constitutional bench hearing the matter.
Doesn't matter. But can we close our eyes to Sarvananda Sonwal? Because Sarvananda Sonwal had not been referred.
This judgment heavily relies on Sonwal, my lord.
Maybe, but this question, Sarvananda Sonwal had not been referred. All it says is what? We feel following question need to be answered by, most of them are a substantial question of the interpretation of constitution which have decided by minimum of so and so.
My lord.
And whether 6A violates, so that is the main question. This is only a subsidiary. Would an influx of 11 into state constitute external aggression? If the answer is already given by another larger bench, can we ignore it? Mind you, it's a very, check out that Dayanand's case where what is to be followed and what is not to be followed had been spied. Does it say so? Otherwise, it will be a very dangerous situation. You are asking the High Court to close its eyes to a Supreme Court judgment. Don't look into it.
Like I respectfully submitted, my lord.
Your respectfully word will not improve your case, Mr. Awan. Show us the law that in such a situation, High Court is bound to close its eyes to all other judgments of the Supreme Court.
I'm not
Show it.
submitting.
If yes, we'll close our eyes. We'll not look into it.
I'm only saying that this should be considered that because it is subjudice before the
No.
5 judges bench.
And what happened to the 5 judges? Give the particulars. We'll check it up. See, question 4 is whether 6A violates Article 335. Okay.
My lord.
This is a question set for a larger bench. Read at para 35. As section 6A must be deemed to be valid until larger bench decides this matter, we proceed for the purpose of this order on the footing that 6A is valid.
But the next line in the 4 is what an influx of illegal migrants into. So
But
that is
as
not-
the objector you said that he was inserted into category to implement part of the assignment. Various these largely contain 5-6 reader for the purpose of all purpose of claim to assignment. And what is Sambalita Mahasangha deciding? Mr. Awan, they are deciding whether it should, that 71 should remain the cutoff date or it should go
to the constitution.
beyond that.
Beyond that.
Number one. So this influx of illegal migrants will be for the purpose of people who came prior to that date, even if it is decided. It cannot be for the people who came subsequently. We are deciding people who came subsequently.
That very well, my lord. My only humble submission is that should
You
not be
cannot.
considered as any enemy alien, my lord. Because
You
it was
cannot.
submitted.
Why? Your statement is not sufficient, Mr. Raman. When we are considering specific provisions in a judgment of a Supreme Court, your mere statement is almost nothing. It's only your wish. It's not a submission. If you want to submit, it has to be legally acceptable and tenable. Otherwise, tomorrow, everybody will come, one side produces a Supreme Court judgment, other side will say that I feel that it is not applicable without any reason. And you expect the court to discard all Supreme Court orders, because why? One council feels that it is not applicable. We are hearing you, but you please substantiate.
That was my respectful submission with regard.
Mr. Awan, there's a difference between a wish, expressing a wish and making a legal submission. What you have done till now is you're expressing your wish. Submission has to be backed by relevant provisions of law. Produce it.
This is what I referred to, my lord.
We are not prohibiting you from producing any law. You produce it, please.
We come to my last submission, my lord.
What was the prayer in these petitions before the Supreme Court? Assam Sammilita Mahahova. What
They
was
challenged
the, why
6A.
was it filed?
They challenge 6A,
6A.
my lord,
6A gives citizenship to people who came up to 1966.
1966.
That is the challenge.
My lord.
And that was not decided by the court.
Not
6A had been referred to a larger
My
bench.
lord, my lord.
Okay. And while referring it was a corollary question was also there, would an influx of illegal migrants constitute external aggression and or internal disturbance?
My lord.
This the court itself had answered. It has taken note of some lot of materials produced before the court, some affidavits, etc. The large-scale influx of illegal Bangladeshi immigrants has led to large tracts of sensitive international borders being occupied by foreigners. However, large-scale illegal migrants have not only threatened the demographic structure of the area, but have seriously impaired the security of the nation. Court itself is that answer. In this case also, they have accepted it. Nowhere it is said that we are disagreeing with all this. These are various documents quoted there. In this background, how can we ignore the other one, other judgment, which is a complete judgment? More so when that judgment is not referred. What is referred is question of 6A. The ancillary aspects are not referred.
The very fact that. this
And
issue-
more so, not only after referring, it says, referring 6A, court says that till the larger bench decide it is valid.
That is regard to 6A. my lord.
And other question is the supplementary question to 6A,
My lord.
same paragraph. If 6A is valid, the earlier finding of the court is also valid till it is decided otherwise by the larger bench on being referred. We cannot take a different view. Otherwise, we'll be committing a contempt of the Supreme Court in saying that we are not following one complete judgment. Merely because an ancillary question had been also referred to the larger bench along with the main question. The main question, the Supreme Court, after referring, says that till the larger bench decide it is valid according to us. The ancillary question, which had been earlier decided by a larger bench of the Supreme Court, would also have to be considered to be valid till such contrary decision is given by the larger bench. Otherwise, you are asking us to commit a contempt of the Supreme Court by saying that ignore it. Don't even look into that judgment of the Supreme Court. Are you to status to keep larger bench? What is the status of the Supreme Court? Just find out. Find out from the Supreme Court website what happened to that.
My internet is not working very fast.
It'll come the internet. Net is not working. Just check out. Give the particulars. No. The referring bench on the main question itself says that till it is decided it is valid. How in the ancillary question we now say this is not valid because it is regular? That is the final judgment of the Supreme Court. No, and that has attained its finality and binding upon till contrary judgment is given by a larger bench. Dayanand Hetu. Even I think in Dayanand also, just check up, please.
My lord.
Provision is, there is a laid down law by the Supreme Court. In another coordinate bench seeks to take a different view, refers the question to a larger bench, till the larger bench decides the original judgment, it's valid and binding on all. Meaning thereby, then in the interregnum, there is no implied stay of that judgment, merely by virtue of it being referred. Even that is in that officially created versus Dayanand also. I think this is possibly this principle is there somewhere. Or otherwise, a real havoc will be created. All that you are required to do is to get one principle of law referred by another coordinate bench to a larger bench. Don't do anything, then this law becomes redundant till then. Not valid anymore. That is not the principle, I think. Principle is once the larger bench takes a contrary view, from that point onwards, that view will prevail. Till it is done, the judgment which has attained otherwise finality will prevail. Yes, Mr. Nath, what is your view? Is Mr. Mojumdar available? Yes. Okay, you only answer. Mr. Awan tries to say that Mr. Mojumdar relied on Harmananda Sonwal 1 on certain paragraphs to make some submissions. Okay. Mr. Awan says that in the Harmananda Mahahoba that matter, which was on a totally different legal issue, validity of section 6A was referred to a larger bench. Along with it, one ancillary question was also mentioned in that reference. And because the ancillary question had been referred, Mr. Awan submits that whatever was provided in Harmananda Sonwal will now not be valid anymore till the larger bench decides the ancillary question. I don't think that is the correct proposition. No, that is otherwise attained finality. Suppose on the ancillary question being referred, the Constitution bench takes a different view. From that stage onward, we have to ignore Harmananda Sonwal. But as long as it does not take any view, Harmananda Sonwal will be binding for us. We can't ignore that judgment.
Lordship, on the ancillary issue on which it has been referred.
And moreover, on the main question referred,
Lordship.
in Harmananda Mahahoba itself, the Supreme Court provides that till the larger bench decide, 6A is valid according to us. As a corollary, as regards the ancillary question referred to the larger bench, till the larger bench decides, the already valid principle decided in Harmananda Sonwal will remain valid and be binding on us.
Yes. We should. We should.
Mhm. Lower. For the preparing a comment.
Organizational one or issue that we have taken, we have yes.
So this is pending.
Hello.
Councillor requested to prepare a common compilation duly indexed and circulated. No, that's the order. Yes.
And the ancillary issue.
last humble submission, my lord. That the learned counsel for the union, my lord, have extensively argued on the migration since 1905, my lord. With deepest respect, my lord, and utmost humility, my humble submission is that, my lord, those arguments should not have a bearing in this case. Now, what is the migration in 1905 has to do with the rights of declared foreigners being defined, my lord, determined.
We don't know. If you put your submission in a question form, how can we answer? You put your submission in an answer form
My
so
lord,
that we can take note of it.
my lord, now if a migration happened in 1905, my lord. Now, if motive is attributed,
Was it a one-time migration in 1905 or it was a continuous event?
my lord, any kind of migration,
Mr. If there was any reference to 1905, if the act of migration in a similar context is continuing, then it has a relevance. If 1905 was an isolated migration, unconnected with the present migration, then what you are saying is right. Do you have any material to show that 1905, the context, it was an one-time isolated incident, which never to be repeated again? And the subsequent migration problem we are facing now is a totally different kind of migration. Do you have any material to substantiate it?
not the,
If you have, please produce.
the entire issue of
See, the river flows. When you look at Brahmaputra in Dibrugarh, you see it is flowing. When you see next 10 kilometers, it is flowing. If you see it at Dhubri, it is still flowing. It's a continuous flow. If you want to say that the flowing of the river Brahmaputra in Dibrugarh is totally disconnected, disjointed from the other part of the flowing river, then we understand that Dibrugarh is an isolated thing, and any elements particular to Dibrugarh will not be applicable to the Brahmaputra
not,
in
it
the
is
rest of the
disjointed
time.
by Article 6, my lord.
Sorry.
It is disjointed by Article 6, my lord.
Articles?
Any person, my lord.
Article 6 is doesn't depend on migration.
That's
We
the
are,
baseline of citizenship.
Mr. Awan, we are asking the question on migration, not on the status of the migrated people. Article 6 or that section 6A or whatever it is of the Citizenship Act determines the status of the migrated people. But this does not disjoint the flow of migration. There's a difference between the two.
Attributing motive to migration before Article 6, my lord.
So now you mean to say that the motive to migrate as on now, the person migrated yesterday and the person who migrated in 2005 are different. Substantiate with materials.
I'm not saying about 2005, my lord. There are 3 stages, my lord. One is, my lord, any person who migrated before the commencement of the Constitution is a citizen of India. After this-
Mr. Awan, we are again putting the question back to you. This classification is regarding what kind of a status is to be given to these migrated people.
My lord,
Whether they will be citizen, they will be non-citizen, they will be limited citizen, whatever it is.
Hello.
But the act of migration is a continuous flow. You are on the effect, we are on the act. The effect of giving a status to a particular period during which the migration took place cannot make it to be a different kind of a migration. The Brahmaputra in Dibrugarh may be called Lohit. In this thing, it may be called a different name. It's going to be Atwa. After all, it's the same flow. In Tibet, it is again given a different name. Flow is same. Effect of the flow is the law had given different status at different time. So by taking up the issue regarding the effect given by law at different time, you cannot, can you say that the flow itself is different? Or the purpose of the flow itself is different?
That is my respectful submission.
Your submission should be always based by reason, Mr. We are repeatedly saying. Otherwise, it's basically it's only a statement you are making, unsubstantiated.
If I may say this, your lordship. So the motive attributed was that the migration happened to take this land away. Have we ever?
So now the migration is not with a motive to take the land away.
No, I'm talking from pre-independence period. my lord.
Understand? What is submitted by the other side is based on some Supreme Court judgment. Something recorded in the Supreme Court judgment. That is what was referred before us. Now you are asking us to take a different view, saying that what is referred by the Supreme Court is not applicable as of now. So definitely, if you are taking such a strong stand, you'll have to substantiate your stand. A mere statement will not change the course. If you have it, please produce. We are hearing you, seriously hearing you.
My lord,
And we will hear you as long as you want to be heard. But we want something to substantiate. Suppose we take a view in your favor now. We'll have to justify you with some reasoning. Give us the materials for that reasoning.
I will read Article 5 and 6, my lord,
Of the
the Constitution of India, my lord.
Constitution for your. Yes, please. Start
My lord,
reading.
citizenship at the commencement of the Constitution. At the commencement of the Constitution, every person who has his domicile in the territory of India and who was born in the territory of India or who has been ordinarily resident in the territory of India for not less than 5 years immediately preceding the commencement shall be a citizen of India. Article 6, my lord. Rights of a citizen of certain person who have migrated to India from Pakistan. Notwithstanding anything in Article 5, a person who has migrated to the territory of India from the territory now included in Pakistan shall be deemed to be a citizen of India at the commencement of this Constitution if he or either of his parents or any of his grandparents was born in India as defined in the Government of India Act 1935 as originally enacted. And in the case where such person has so migrated before the 19th day of July 1948, he has been ordinary resident in the territory of India since the date of his migration. Now, my lord, by virtue of this article, my lord, any person who migrated before this is a citizen of India by virtue of the Constitution, my lord. Now, my only respectful
I
submission.
think respondents are not denying it.
No, what was been argued, my lord, the referring to migration 1905, 1927, what Jinnah told Moinul Haq Chaudhary, my only respectful submission is that those things should not have any bearing on determining the rights of
Why?
declared foreign national. For the simple fact, my lord, suppose someone came here in 1905, my lord, how can motive be attributed to that? It is, they are citizen of India now.
And we don't know. The Supreme Court has recorded it.
No, Supreme Court doesn't say that
You go
someone
and
came
raise
in
the question in the
1905 is not
Supreme
a
Court.
citizen of India.
No, you raise the question to Supreme Court. Why you are asking the question to us?
No, mal, I'm only making submission, my lord, that by saying if someone came in 1905, that attributing motive to the migration is taking away their right to live with dignity, man. Because they are citizen of India by virtue of 5 and 6, my lord. So my only submission is that should not have any,
No, we have not understood your submission, Mr. Awan.
my lord, my submission is, my lord.
We are Supreme Court had put in certain of its judgments, the motive, implication, purpose of a particular kind of migration, which is a continuous migration, and continuing till today. Okay. And had traced back the roots to 1905. The Constitution of India and the laws framed thereunder had given certain legal status to some of these migrated people depending on the period during which they had migrated. How can giving a status to these migrated people depending on during the period during which they had migrated can change the purpose and motive of the migration, which is judicially recognized by the Supreme Court to have been started in around 1905 and continuing as on today. This is, we are unable to reconcile from your submissions. Whatever legal right the Constitution had provided, whatever legal right the statutes have provided, definitely no one is questioning that right.
I know.
Neither are the respondents questioning. Those rights, how does it impact the motive and purpose of the migration that had already been judicially accepted by Supreme Court? And mind you, all the Supreme Court judgments are also after these constitutional provisions, and so we understand Supreme Court were aware of these constitutional provisions and the statutory provisions when these attributes and motives were given to this migration.
Lord, it's from 1905 till now, my lord.
So if you have any material with you to show that the motive and purpose of the migration in 1905, which is continuing till today, in spite of being taken note of by the Supreme Court and judicially put it in its judgment, has changed its course or motive has changed. If you are trying to say that,
My lord,
I think this is what you are trying to say,
my lord.
you have to show appropriate materials on record, bring it on record, that by reading this material, we can also take a view that the purpose and motive of the migration has changed in the meantime.
May I say this, your lordship?
We are told you we are ready to hear you to any extent, but it must be something
My lord, that's what,
reasonable.
on the motive, my lord. The motive was merger of this part of the land with Bangladesh. In the last, say, 117 years, there has been no effort being made to capitalize that motive. There absolutely no effort being made to capitalize that motive. So just because something is said somewhere, my lord, does not mean that that motive is correct, my lord. That is my respectful submission.
So now you are asking you to question asking us to question the Supreme Court. Can we do it?
Stating the fact, my lord.
Understand? You are asking the High Court to now to question the Supreme Court on the wisdom of its judgments.
Deeply obliged, my lord. I conclude my respectful. Thank you so much for giving me this opportunity.
But we are seeking answers from you. If you have, please tell us.
I have not come across anything which suggests any merger with Bangladesh, my lord. Deeply obliged.
Nothing more.
My lord, I conclude my submission.
Yes,
Thank you so
Madam
much.
Ghosh, you want to add something? Mr. Awan basically submitted on the submissions of the respondent on the question of aggression,
Yes.
because I think Mr. Mojumdar, I think, referred to some provisions of the Supreme Court judgment in Sanmita Mohalla. Also, some of the paragraphs in Harwanda Honwal. Mr. R.K.D. Chaudhary referred to some further materials.
Yes, Lordship.
And his argument is basically is that the motive and the purpose that was attributed by the Supreme Court from 1905 is not applicable as on now. And we repeatedly tried to know from the learned young counsel, why is he saying so? Whether he has any material. Other than very nicely presenting it, and mind you, you are asking us to take a view different from the Supreme Court. We need at least something to form a view, even if we at all can do it.
Lordship, before I argue on just on Article 21, just rebuttal to, especially on right to food. My colleague also would like to make some certain submission on the rebuttal of the submission being made by the government side. Lordship.
On which
On
point?
Article 14, Lordship, and the Foreigners Act. And the
So
Foreigners.
you want to continue now, or
And she will continue first and then I.
then you will do?
Yes,
Your issue is basically right to food,
food, Lordship.
right
and
to right to shelter, right to food, and right to
Health.
health and education.
Yes, Lordship.
Much obliged, Lordship. Lordship, I want to start by just outlining the main issues that I'll be talking about.
Yes.
Yes, Your Lordship.
Hmm.
Lordship, I just want to refer to section 3(2) CC of the Foreigners Act, because that has been relied upon on occasion by this honorable court.
No, first tell us
Yes.
on which point you would like to argue, so
Specific-
that we can start thinking from that point of view.
Yes, Your Lordship, on
Because
foreigners.
Mr. Awan had made it very clear. He was trying to basically submit on the submissions of Mr. Mojumdar and Mr. Chaudhary, RKD Chaudhary, on the question that aggression.
Hmm.
He was basically arguing on that. On what point you are arguing?
Three questions, Your Lordships. One is that because I think the state has argued that because of the operation of section 3(2) CC of the Foreigners Act, any declared foreigner can be required to bear the costs of their own expenses while living on the territory of India. I wanted to just respond to that. The second issue, Lordship, I wanted to refer to was the question that has already been raised by my learned friend, Mr. Aman Badul, on the question of whether one can impute Bangladeshi citizenship to declared foreigners. Just wanted to,
Impute,
as in one can attribute
attribute.
yes, Your
Attribute
Lordship.
what?
The citizenship of Bangladesh to declared foreigners, Your Lordship.
Sorry, we couldn't understand your say.
As in,
Attribute citizens of Bangladesh to be foreigners.
no, Your Lordship, I'm sorry.
So do you mean to say Bangladesh is a part of India, that if a person is from citizen is not a foreigner?
No, Your Lordship, I mispraised myself. What
Yes,
I'm
please do
saying
it.
is that if a declared foreigner is a declared foreigner as declared by the Foreigners Tribunal, can the same person also be considered to be a citizen of Bangladesh? Is the point
No.
that I'm trying to
A
raise.
person declared to be foreigners under these laws is supposed to be a person who entered the state of Assam on or after 25/3/1971 from the specified territory, where specified territory is a defined concept under the law.
Yes, Your Lordship. Lordship, if I may bring your attention to section 8 of the Foreigners Act, that may help. answer this
Section
question.
8 of the Foreigners
Yes, Your
Act.
Lordship,
Okay.
only section 8.
Determination of nationality.
May I read the section, Your Lordship?
Yes, please. No, you argue in any manner if you like.
Okay, Your Lordship.
Only thing, if you go out of the four contours,
Yes, sir.
we are going to tell you.
Yes,
If you are within the four corners, we'll hear you.
certainly, your lordship. I'll
Okay,
work with your, under your lordship's guidance on this. So section 8, your lordship states that when a foreigner is recognized as a national by the law of more than one foreign country, or where for any reason it is uncertain what nationality, if any, is to be ascribed to a foreigner, that foreigner may be treated as the national of the country with which he appears to the prescribed authority as to be the most closely connected for the time being.
So this is two situations.
Yes, your
One,
lordship.
a person, a foreigner is recognized as a national by law of more than one foreign country.
Yes, your lordship.
Suppose X is a citizen of two foreign countries. Then what will happen? And the second situation envisaged is the nationality to the foreigner cannot be ascribed in any manner. No one knows from where he is. These are the two situations contemplated under 8.1.
Yes,
Yes,
sir.
now please submit.
Your lordship, then if I may ask you to jump to
Ask me.
section,
What do you want to ask me?
no, your lordship, just request you to come to section
You
9.
want to request to
Yes,
say
Your
section 9. Okay.
Yes, your lordship. I apologize, your lordship. Section 9, your lordship says, if in any case not falling under section 8, any question arises with reference to this act or any order made or direction given thereunder, whether any person is or is not a foreigner or is not a foreigner of a particular class or description, the onus of proving that such person is not a foreigner or is not a foreigner of any particular class of description, as the case may be, shall, notwithstanding anything contained in the Evidence Act, lie upon such person. Lordship, I'll quickly summarize my submission here, which is that the foreigners tribunals are making a section 9 determination,
Section 9.
which is that whether a person is or is not a foreigner belonging to a specific class of foreigners, as has been laid out under section 6A and the Foreigners Tribunal Order 1964. They are not making a section 8 determination, your lordship, which has to be done by a prescribed authority, which is not the Foreigners Tribunal in this case. The determination that the foreigners,
Why do you say in there not falling under any question reference or any other order made or direction given whether any person is a foreigner or is not a foreigner of a particular class or description, the onus of proving is not a foreigner, that as the case may shall be on the, this only says on the burden of proof. It does not say about tribunal also.
yes, your lordship, but the,
Section 9 says only about burden.
yes, your
If
lordship,
a particular case does not fall within section 8, section 8 is a person has nationality of two countries, he is a foreigner, nationality of two countries, or where it is indeterminable as to from which country the person comes from. These two situations are covered in section 8. Now, if any of the cases do not fall under section 8, then section 9 is applicable. What section 9 provides for?
the reversed burden of
The
proof, your
burden of proof is shifted to the person concerned
lordship.
and not on the state.
Yes, your lordship.
If it is a case under section 8, burden will be on the state.
Yes, your lordship.
If it is a case not under section 8, burden will be on the person concerned.
Yes, your lordship.
9 does not say anything beyond that.
Your lordship, if I may, what the language of 9 and language of 8 are quite different, because the determination that language that 8 is imagining is a positive determination of nationality. Essentially, I am a foreigner, but which country's foreigner am I? Section 9 is saying, am I a foreigner or not a foreigner? Or if I'm a foreigner, if I belong to a specific class of foreigners. That is independent of a positive determination of nationality under section 8 is my submission, your lordship, because the language of both these sections,
Sorry, we
But
didn't
deliberately-
follow you. What positive?
lordship, under section 8,
Huh.
the question is, if it is uncertain, as your lordship has said, which nationality?
No,
that
we
can
have
be-
not said.
As-
The language of the act we have read out.
Yes, your
We have
lordship.
not said anything. Moment we say something, it will be a judgment.
Yes.
So we don't say anything. We only hear you.
Yes, your lordship.
And sometimes if we don't understand, we point out.
Yes, your lordship.
That's all.
Yes, your lordship. So what the act says
Mm.
is that if it is a foreigner is, so in under section 8, we already know that this person is a foreigner. The question that is being raised before us or before the prescribed authority is not whether or not this person is a foreigner. It is simply when a foreigner is recognized as a national by the law of more than one foreign country, or when it is uncertain which country's national he or she is. My submission, Lordship, is that under section 9, the question is very different. The question is whether or not that person is a foreigner in the first place. And when the tribunal makes a decision or passes an opinion, that is the opinion, that is the nature of the opinion of the tribunal, Your Lordship, that this person is a foreigner, i.e. not an Indian citizen, because that person has failed to discharge their burden under section 9. And this person is a foreigner who belongs to a specific class, as has been created under section 6A. But section 8, Your Lordship, which is a positive determination of nationality, that is not a determination that the tribunal has gone into. Therefore, my submission is only this, Your Lordship, that yes, I am a foreigner as per the opinion of the tribunal, but the citizenship, the nationality of Bangladesh may not be attributed to me till a determination is made under this section 8.
Why?
Yes, Your Lordship.
Why?
Why, Your Lordship? Yes, Your Lordship. Simply because the question that is asked or that is imagined to be covered under sections 9 and section 8 by the very phrasing of section 8 and section 9 are different, Your Lordship. Because section 9 does not use the term nationality anywhere, Your Lordship, and section 8 does.
So you want to mean to say you are a foreigner without any nationality?
Certainly, Your Lordship, I may be stateless. The Passports Act imagines
Stateless?
stateless persons, Your Lordship. Our laws do imagine stateless persons. Or a section 8 determination
So
may be
even
made
if you are stateless, how does it matter?
only for the limited.
No, sorry, we are unable to understand what you are trying to say.
Yes, Your Lordship.
We are going in a totally tangential different direction.
Your Lordship, if I may
See,
clarify why.
There is a provision of a specified territory. Where is that one? Person coming on or after 20?
6A, Your Lordship.
6A.
Yes, Your Lordship. Can you see the citizenship act? It's right there.
So these are determinations of 6A.
Yes, Your Lordship.
6A is specified territory. Specified territory is defined. So it is understood you are from the specified territory.
No, even while section 8(1), my learned friend is reading, if we read the entire paragraph, it clarifies. When a foreigner is recognized as a national by the law for more than one foreign country, or where for any region it is uncertain that nationality, if any, is to be ascribed to a foreigner, that foreigner may be treated as the national of the country with which he appears to the prescribed authority to be the most closely connected for the time being in the interest or sympathy, or if he is of uncertain nationality of the country with which he was last so connected. So the submission made by my learned friend is that the tribunal, while deciding the matter, should not ascribe any nationality status to the person as Bangladesh. Because they are.
And no one is ascribing any nationality.
That is what.
Indian tribunals do not declare the citizenship of a person to be from Bangladesh.
Yes.
They only declare that they have come from this specified territory after that cutoff date. That's all.
And as per this section 8(1), as because the persons are mostly connected with that particular territory, sometimes possibly it may happen.
And which is the provision for reference to a tribunal? I think 2.
64. There is an order 64.
Everything is specified territory. Even people who came before 1966
Yes, Your Lordship.
is from the specified territory. Between 66, 71, specified territory.
Yes, Your Lordship.
After 71, specified territory.
Yes, Your Lordship.
Specified territory is clearly defined. So this is what is attributed.
Your Lordship, if I may just quickly summarize this argument, which is that because the Foreigners Act uses these two terms.
But we have to
distinctly-
read all the laws conjointly. You can't
Yes, Your Lordship.
read only section 9 in isolation
Your Lordship.
and shut your eyes to all other provisions of all other statutes.
No, Your
But when you read everything conjointly, including the tribunal orders, Citizenship Act, provisions thereof, the answer is there.
Your Lordship, on reading all these provisions conjointly, my only submission is that none of these, apart from section 8, none of these point to the word national or nationality. They all use the term foreigner, Your Lordship. So attributing the nationality of a country and then the
Sorry,
consequences that come from it.
Finding it to be without much of a reasoning.
Okay.
Although you were trying to, very nicely, you were trying to present it, but why are you saying so?
Your Lordship, the reason
I
I was making
understand,
this
you
point.
were taking note of only section 9 of the Foreigners
No,
Act.
Your Lordship, section 8 and section 9 and.
You
the
were taking
Foreigners
note of
Tribunal Order.
only 8 and 9 of the
Yes, Your
Foreigners Act.
Lordship.
But how can you shut out all other provisions, including 6A of the Citizenship Act?
Your Lordship.
There, from where these people are coming, the statute itself provides for it.
Yes, Your Lordship.
So how can you take out those provisions of the statute and then say that I am a stateless person?
Your Lordship, if I may, in international law, the determination of statelessness.
No, we are determining national law. We are not determining any
Okay, Your
international law.
Lordship. Yes, Your Lordship, certainly.
International law is applicable only when the national law will provide somebody to be stateless.
Yes, Your Lordship.
But here is a case, it is not providing so. National law clearly provides that these are persons who came from the specified territory,
Yes, Your
and
Lordship.
specified territory is clearly defined.
Your Lordship, simply, my submission is this, that simply because a person came from the specified territory does not mean that they are citizens of Bangladesh, simply because it is also a function of the operation of Bangladesh's citizenship laws, Your Lordship.
Sorry,
One
no.
way,
From the point of view Bangladeshi law, it may be, but point of view of Indian statutory law, it is not so. Otherwise, we are making Indian statutory law redundant by taking recourse to Bangladesh statutory laws.
Your Lordship.
In other words, forget about Indian constitution, import the Bangladesh laws, which will be the governing field here. How can it be? It's a basic rudimentary principle, it's against it. So tomorrow, you argued in the laws of England, it is provided this. The laws of India provided something different. Shut the books providing for the Indian laws, borrow the English laws and put it everything. Indirectly, this is the implication of your argument.
Your Lordship, if I may just make one small submission in this case, Your Lordship. One is that we are, as a country.
Madam,
Yes, Your
we
Lordship.
understand what you are trying to say.
Yes, Your Lordship.
It's not that we are not understanding or not appreciating.
Yes, Your
We
Lordship.
appreciate also. But the implication thereof will be that,
Your Lordship,
that
only,
you give a go by to the Indian statutory laws. Follow the Bangladeshi statutory laws, means import the Bangladesh law to India, follow that law. Shut out the Indian statutory laws, and then accordingly say that these people are stateless people, because Bangladeshi law doesn't say them to be citizens of Bangladesh.
Your Lordship, may just one small point on this, Your Lordship. I know I'm being very persistent, but I promise this is the last point that I'll make
No,
on this.
no,
and then I'll-
we are not binding you any last or first. You can submit as much as you want,
Yes, Your
but
Lordship.
we are only putting the questions because we are seeing some certain flaws in your argument.
Yes, Your Lordship.
We are just pointing out so that you can,
Yes,
that's
Your
why
Lordship.
initially I said you can argue anything within the 4 acceptable corners of law.
Yes, Your Lordship. So, Your
What
Lordship,
you are now trying to argue is one of the rudimentary principles of importing foreign laws and shutting out the local laws.
yes, Your Lordship.
That is not permissible in any form of legal principle.
Your Lordship, just on this point.
It will be dangerous, I am telling you.
Yes, Your Lordship.
Suppose now we go to that question of that same-sex marriage, which is highly popular nowadays. It's going on in the Supreme Court. I think Canadian law permits, Madam
Yes, Your
Ghosh.
Lordship. Yes, Your Lordship.
I think Canadian law permits. By following your principle of argument, suppose the Indian law does not permit,
Yes, Your Lordship.
now your argument will be close down the Indian laws, import the Canadian law, and make it applicable.
Yes, Your Lordship.
That's why I'm saying on a rudimentary principle, this is impermissible. So even if the Bangladesh laws may provide for that these are not their citizens, impliedly they are stateless. But to give a declaration, we have to import the Bangladeshi law in India now, shut out the Indian statutory provisions on this subject, then come to the conclusion that they are stateless, and then hear you further.
Yes, Your Lordship. Lordship, we do frequently conduct that exercise. Actually, when we look at the effect of Bangladeshi law, especially just to give some examples to show that this is not entirely not done within the Indian framework. When it comes to, for example, victims of trafficking, it's regularly an assessment of that victim's nationality is done in conjunction with Bangladesh before they're repatriated. Even in cases of deportation with countries of not just Bangladesh, but many other countries. So it is done, Your Lordship, in certain circumstances. My only submission is that a section
Madam,
8.
we are not what you had done in a specific case.
Yes, Your Lordship.
We are on the basic acceptability of legal principles.
Yes, Your Lordship. So then, Lordship, I will conclude this.
I gave
argument.
you one example.
Yes, Your Lordship.
I can give you one more example. Certain acts are not they are not a criminal offense in certain countries. In some countries, it is an offense.
Yes, Your Lordship.
Suppose X act is a criminal offense in India,
Hmm.
Indian statutory law provides for. Can you shut out the Indian statutory law, import the law of another country, which provides that that act is not a criminal act, and then take your defense in a trial that I have not committed any offense?
Yes, Your Lordship.
Why? Because under the law of so country, this is not a criminal offense.
Your Lordship, may I
You please
respond?
shut your eyes to the Indian laws. It may be an offense. Import the law of the other country. Now agree with me that I have not committed an offense. Will it be ever acceptable in any legal system?
No, Your Lordship, and the reason it won't be acceptable is because when we criminalize actions, we criminalize
So
actions.
now
under
you are
a
trying to
jurisdiction.
distinguish between this kind of people having illegal migrant and criminal offense.
No, Your Lordship.
So
I-
in illegal migrant, it is acceptable. Criminal law, it is not
Your
acceptable.
Lordship, I'm not disputing that these are declared foreigners, Your Lordship. At no point am I disputing that. I am merely saying.
Ultimately, it's a good debate, but we are not leading anywhere.
Oh, Your Lordship, I will conclude this argument here by
You
simply
don't
relying on
conclude, you
section
submit.
8.
But
the-
please answer.
Yes, Your Lordship. The distinction here is that attribution of citizenship, Your Lordship, is a status. That I am either a citizen of X country or I'm not a citizen of X country. Therefore, it has to be a finding that is made in fact, Your Lordship, which is why section 8 exists. If there was no need for attribution of nationality or lordship, we would not need a section 8.
Madam, you are supposed to submit on the point of this Article 14.
Yes, Your Lordship.
how Article 14 is connected with this, section
Lord-
8 and 9?
Lordships, I said I'll submit on Article 14 and also on the question of Foreigners Act specifically
No, you have
whether
not uttered a single word about Article 14.
I can move on to Article 14, your lordship.
Where?
I right now, your lordship. I can move on to Article 14 right now.
But what is the connection of these two sections with the Article 14?
Your lordship, these are two separate arguments. This is not, this argument has nothing to do with Article 14. I respectfully.
Okay.
We are not supposed to listen to you on this point.
So
We are
you-
supposed to
I
listen
apologize.
on
You
the
said formulated your point on Article 14, but you argued on something different.
No, your
And
lordship-
Article 14 argument is yet to come. Okay?
no, your lordship, I
The way
apologize.
you are comfortable.
I apologize. I'll move on to Article 14. I had said that I'll argue on Foreigners Act
But
and
this
Article
act
14.
argument, still we are unable to understand what exactly you want to say, because I have to write a judgment, mind you.
Yes, your
I
lordship.
am hearing you,
Yes, your lordship.
not that I'll ignore you.
Yes,
I'll definitely, I'll have to take note of your argument.
yes, your lordship.
What is your argument?
My argument, to summarize, is that declared foreigners may not be treated as citizens of Bangladesh. They are declared foreigners, no doubt, but none of the disadvantages that come
No.
with being,
The opinion given by the tribunal under the Indian laws, under the Indian statutory provisions of the statutory laws would be that that is a person who entered the state of Assam from the specified territory after 25/3/1971.
yes, your lordship.
Yes.
Yes, your lordship.
And this has to be understood in the context of the Indian statutory laws.
Yes, your lordship.
It's nothing like attributing or non-attributing. No one is attributing anything.
Yes, your lordship.
The determination made is the person concerned has entered the state of Assam, mind you, not even India also,
Yes, sir.
from the specified territory after 25/3/1971.
My,
That's the declaration.
yes, yes, your lordship.
And there is nothing called any attribute. So where he had entered, state of Assam. From where he had entered, from the specified territory. Specified territory is a defined concept. When he entered, after 25/3/1971.
Yes, your lordship.
These are the three elements of that declaration.
Yes, your lordship.
And none of the tribunals had declared anybody to be a Bangladeshi.
Yes, your lordship.
No, then why are you, how is it relevant for us, your
Because-
arguments?
Yes, your lordship, because any disadvantage or any
Doesn't
deprivation,
matter.
yes, your lordship.
None of the tribunals have ever declared anybody to be a Bangladeshi. Have they done it? No. Show me one judgment if it is there.
No, your lordship, there are no judgments.
That's all.
Your lordship, with your
Then why
permission-
should he go into some extraneous consideration?
Only because your lordship,
Whether what the Bangladeshi law provides for? Why should he go into all these questions?
if I may submit your lordship, I only made this submission because the state has relied on certain judgments to show that because these are Bangladeshi nationals,
No.
they should be treated in a certain manner. I'm only clarifying on this point. Our
No one had
submissions.
made that submission, nor the Supreme Court had provided.
Your lordship, that because of the reliance on, for example, the FEMA regulations and every other regulation that states that foreigners.
FEMA,
who-
we have already rejected.
Much-
FEMA has, it's almost unconnected.
Yes, your lordship.
FEMA is on foreign exchange.
Yes, your lordship.
If a foreigner buys property in India, in what currency he will be paying? The Reserve Bank of India intends to regulate and control that transaction. That's all.
Yes, your lordship.
It's nothing to do with any illegal migrant.
Your lordship, then may I move on to the Article 14 argument, your lordship? I've tested your patience enough. I will just move on to that very quickly.
How long will you take? We'll continue tomorrow because his lordship is having a single bench.
Oh, yes, your lordship. Your lordship, I'll take 5 more minutes, but I may also continue tomorrow if your lordship pleases.
If you can't complete, why do you start now?
Yes.
You have a good beginning tomorrow in the morning then. Article 14, just tell us in one line, what is your submission?
Right now, your lordship? Yes, your
In
lordship.
one sentence, not an elaborate one. What exactly you want to submit on Article 14?
Article 14, your lordship, applies to citizens and foreigners alike And the reasonable classification test may be applied on the basis of the statute and the right being claimed by the foreigner. This is it, Your Lordship.
Sorry.
If I as a foreigner, I'll phrase it differently, Your Lordship, I'm sorry. If I as a foreigner, I'm claiming a right under Article 21, which is applicable
No,
to
you're on
citizens
14,
and-
not on 21. 21 we will hear separately. There's
Yes,
a
Your
lot of
Lordship.
arguments coming.
My
on 20.
argument on 14 is actually contingent on 21. I'm saying that if I am claiming a right that is constitutionally guaranteed to citizens and foreigners
What
alike.
you, now we ask you the question.
Yes, Your Lordship.
What is Article 14?
Your Lordship, I'll read out.
Without
the-
looking into the book, just tell us what is Article 14 so that we can understand your concept of Article 14.
Equality before the law, Your Lordship, and equal protections of the law.
Equality before the law
and
and
equal
equal
protection.
protection of
Yes,
the
Your
law.
Lordship.
How the Supreme Court had interpreted these two phrases?
Yes, Your Lordship. Your Lordship, the Supreme
Equality
Court-
between whom?
Equality between likes, Your Lordship. So TMA Pi says, if I'm equally situated, then I shall receive equal treatment. If I'm unequally situated,
So-
yes, Your Lordship.
Between two persons who are declared to be people from illegal migrants, because of their similarity, if one is given another treatment, that other is given some other treatment, they may invoke Article 14,
Yes, Your Lordship.
even by being non-citizens.
Yes, Your Lordship.
But when the comparison of similarity comes with that of an Indian citizen, the claim that the Indian citizen is getting X, Y, and Z, so I am also entitled to X and Y, Z is possibly not available
Your Lordship,
because there will be a dissimilarity between the two classes of people.
Your Lordship, my
So the
submission is it
equal
can.
protection of the law is also as the law is applicable to that particular class of people. The law that is applicable to the other class of people, you don't get equal protection of that law for the other class.
Your Lordship,
Even
my-
TMA Pi you referred has provided
Yes, Your
for this.
Lordship, my submission is that depending on the right that I'm claiming, the protection may extend to foreigners and citizens alike.
No, that is from the point of view of Article 21.
Your Lordship, if I
But
may,
when you come to Article 14, it has to be equal protection to dissimilars are not available. Same law is not applicable to dissimilars. Even there is a judgment of the Supreme Court which says if the same law is made applicable to two different classes, it will violate Article 14.
yes, Your Lordship.
So the argument you are raising will in fact violate Article 14.
Your Lordship, may I just, because I know Your Lordships are in a hurry, but.
We are not in a hurry.
Okay,
Please don't
Lordship.
use
No, Your
expressions.
Lord. No, Your Lordship.
We absolutely prohibit you from using any expression.
No, Your Lordship.
You are free to make any argument on the legal issues,
Apologize.
not on the how the court is behaving or what the court is doing.
I apologize, Your
No,
Lordship.
you
I
cannot,
apologize.
not apologize, you cannot.
Sorry, Your Lordship.
You are not entitled to make anything other than your legal submissions. Legal submissions, you can take as long as you want.
I apologize, Your Lordship. It won't happen.
You are from this place or some other place?
I live in Guwahati now, Your Lordship. I'm originally from Calcutta.
Where do you practice normally?
I'm practicing with Devasmita Ghosh. I assist her on these cases.
Because this is not a tradition of this court normally. No one behaves in this way here. Guwahati High Court has its own tradition, own culture. Please protect it.
I'm very sorry, Your Lordship. This won't happen again. Lordship, I'm relying on, with your permission, a case of the Delhi High Court, Your Lordship, which also relies on a Supreme Court case. So I'd like to refer to both of these cases. Your
What does
Lordship.
it say?
Uh,
I will hear it tomorrow, but what does it say so?
My submission, Your Lordship, is in the Delhi High Court case, which relies on the Supreme Court case. The court has held that two entities, one being a foreign company and one being an Indian company, both of which made a bid for the same tender. Even though one was a foreign company,
So these illegal migrants are also making tender for some law in India.
Your Lordship, in
Hey,
this case,
Madam, have some resemblance of the factual background also of the matters.
listen,
That is a totally different aspect.
Yes,
That judgment is on some tender issue.
so
regarding the eligibility in participation or regarding some discrimination matter to a foreign company,
Yes, your lordship.
Supreme Court held that in the matter of tender, there cannot be discrimination between an Indian company and a foreign company. Both of them have to be given the same treatment.
Yes, your lordship.
That law is not applicable when a person is declared to be an illegal migrant and tries to claim that I also be given the same protection of the Indian laws as applicable to the Indian citizens.
Yes, your lordship.
We'll have to determine what are the laws applicable to this
Yes, your lordship.
declared class of people, and precisely we are trying to make an endeavor to find out precisely that.
Yes, your lordship.
What law will be applicable, what law will not be applicable.
Yes, your lordship.
So that has no relevance for this proceeding.
Yes, your lordship. Your lordship, the Delhi High Court case also relies on a Supreme Court case, your lordship, which is Basheshwar Nath versus Commissioner of Income Tax, Delhi and Rajasthan, which simply gives a description of which right is applicable to what class of persons. I may,
For a purpose of tax laws.
yes, your lordship.
Not the tax laws is a totally different sphere. If a foreign company comes and does some business in India, they are subjected to some of the taxes. They have to pay. That Vodafone case.
Yes, your
Why did it come up? But that principle cannot be invoked for an illegal migrant, saying that give me the same benefits of Indian law as given to an Indian citizen.
Yes, your lordship.
The applicability is different, both of them.
Yes, your lordship. Your lordship, if I may be allowed to continue tomorrow, there is another case I wanted to rely on, but unfortunately I realize I don't have the printout with me right now.
Doesn't matter. What does it say?
It's Bihari Lal Modgil versus, I have the note, your lordship. I'll just tell you the name of the case. I apologize, your lordship. I did not take the
Okay,
printout
so
of that.
what
case.
does it say, sir?
It essentially says, your lordship, is to do with tenancy and
Tenancy.
tenancy, your lordship.
Hmm.
Discrimination between a foreigner and a citizen on whether or not they have the right to retain certain premises as tenants. And your lordship,
Okay, you are a illegal migrant, we will give it a right of tenancy. Provided it is within those prescribed order that the central government may frame, where they may provide for the place of residence, or they may impose restrictions on the place of residence. Within that provision, if you want to take rent of somebody's house, you can do it. No one can prevent you from doing that. So that is accepted.
Okay, your lordship.
Mhm.
It simply speaks on, and I will read from the case tomorrow, your lordship.
Suppose the central government tomorrow frames an order that Guwahati city is a place where the declared illegal migrants will be allowed to reside.
Yes, your lordship.
You can take a rent premises. That will be applicable to you.
Yes, your lordship.
But that doesn't mean if Dibrugarh is not prescribed, you will take a rent in Dibrugarh also.
Yes, your lordship. Certainly, your lordship, to the extent that orders are made under section 3, certainly the central government and the state government, in fact, is at liberty to frame orders.
Definitely.
Yes, your lordship.
Not liberty. You cannot give liberty. It's liberty. It's provided. It's a statutory provision.
Yes, your lordship.
No liberty is required for that.
Much obliged. And apologize, your lordship, once
No,
again.
it's not applies. And so you conclude, or you want to say more tomorrow? If you have some good effective argument, please come forward.
Yes, your lordship.
But it should be firstly effective, secondly relevant for the issue involved. Thirdly, it must be based with relevant, supported by relevant provisions of law. Just a little extra thinking may not be a good submission
Yes, your lordship.
unless it is really you formulate your points. Think about on what legal principles these points are based upon, which factual material and which provisions of law will support your thing.
Yes, your lordship.
And please make your argument.
Yes, your lordship.
You are all welcome. So tomorrow, Because of some personal appearance, we'll take up this matter tomorrow at 10:30. But there are other matters also. We'll hear you for a little particular amount of time, then we'll go over to the other matters. So try to finish it within that time if possible.
Yes, Your Lordship, I will
Be a
finish.
little concise.
Well, the appearance matter, Lordship will take up 10:30.
Because
Lordship.
we have called for two officers.
Yes. They inform. Well, the other three petitions. Well, three other petitions are
Yeah,
listed.
got it. They just see,
Lordship.
ask this secretaries also.
Lordship.
Noted that consequential order for deletion of name from the voter list, arrest and detention camp of the declared past. This may not be necessary. Noted that consequential order of deportation, etc. of the declared foreigners past. This may not be correct approach. And whom it is addressed? The members of the tribunal. What are the members of the tribunal discharging? They're discharging a judicial function. So how can the deputy secretary restrict the tribunals? That you do this or you don't do that. The tribunals render opinion. Opinion the government may accept, may not accept, may act upon, may not act upon. But how can you restrain them from
But
discharging the judicial duties in any manner? Is it not a contempt?
no, I'll check up. I'll check up.
And mind you, all these provisions are statutory provisions. It's already provided in the law. Suppose the tribunal would have been exceeding its jurisdiction and provided for something not provided in law, we understand that you cannot do it.
They have mentioned about the views of the judicial department. Well, I'll check up.
Ah.
I'll check up.
It's a little serious matter.
Tomorrow. at
And
10:30
we
it's-
want to know, relevant for the judicial department's view, who is the author of this view in the judicial department?
I'll check up.
The secretary may not be the author, maybe somebody else.
Lordship.
Who is the author of
No,
this,
in the-
of expressing this view?
In the judicial department, they LR or they lost.
Just find out who is the author of this view, because it's of 2021, must be of somebody earlier.
Yes, madam. Somebody earlier at that point of time.
And how can a court of law accept anything where a government authority is trying to restrict the judicial functioning of a judicial authority?
I'll take the instruction.
I think it will,
I'll get the
cannot and should not be done.
I'll get the clarification, madam. I'll get it. And one of the other three,
And his lordship is asking where the deputy secretary, under what law has got the authority to issue this?
the deputy secretary possibly has said that I am directed to.
The
inform.
deputy secretary also to have applied its own mind before directly asking the foreign tribunal members.
Possibly she has been directed.
Who is directed?
In the file. I am directed to inform you that.
No, no.
In the file.
Even if it
has
is
put it like that.
directed, suppose the direction is contemptuous, will the person do it? Just because somebody has directed me?
No, I'll check up the
The
file.
deputy secretary ought to have sent back the file
Mhm.
that this will amount to a restricting judicial functions.
Correct.
Not that without any application of mind, you'll make it. And ultimately, mind you, this is the deputy secretary who is addressing the tribunal members, not anybody else.
Correct. Well, there are three criminal petitions, petitions criminal law.
In the order dated 11/5/2023, it be corrected as it be corrected to be Borbata PS case number 2109/2021.
Well, this records have
That
not
aligns.
come.
discount.
Lordship.